in this case.
So you're saying Judge Goodwin had to be satisfied that this thing satisfied our law?
Yes, yes.
What case do you have to support that?
Well, here are
I
a
mean,
number of
we
cases.
kidnap people, even kidnap people out of the country and bring them in for trial. And we don't go through local agents. The Supreme Court has actually approved of that. And we have the piracy statutes where, the piracy prosecutions where there is no process being followed under our Constitution to pick these people up in Ethiopia, Somalia. I don't quite know what the principle is that information, as long as we haven't participated in the illegality, we're just receiving the information, and it turns out that that information would not have been obtained legally under our Constitution. Domestically, we don't know. And you're saying there's a law that says, or a case that says we can't use it?
It goes back to the underpinning of Mr. Dugan's motion to compel in the first place.
Well, stick to my question.
Sure.
Why can't the FBI use information that it receives from another country as long as it didn't participate or know of any illegality as it was being developed?
The reason that it shouldn't is because in this case, Mr. Dugan has alleged that there was a joint venture, and he's made a plausible showing
Stick with
of
my
that.
hypothetical for a while so we can get the principle. We can talk about this case. My question to you is, are we barred from using information, reliable information that we trust from another country that was obtained illegally in the other country if it were under our Constitution, but we didn't participate in it and didn't know it?
I'm struggling with the hypothetical because it's so different than the circumstances
I
that
know,
we're
but that's all you need to
facing here
answer is a
today.
hypothetical at this point.
Sure. So hypothetically, if the foreign government acted illegally
Under whose law?
under its law, but where we are here is we don't,
Now, let's stay away from this case for a minute. I want to understand this principle because the whole argument may depend on it. So the question is, let's say a foreign country obtains it legally under the country's law, but it would violate our Constitution. They obtain that information and provide it to us. We didn't participate in their obtaining it. Are we barred from using it?
we're not barred from using it if we are not part of a joint venture. And
Okay,
I'm
so
sorry that
that's
keeps
fair
taking
enough.
me
That's
back
fair enough.
to
So
this.
By that you mean not if we weren't involved, if we weren't in the middle of it.
Right.
So
But here.
So we can take it from the foreign country and use it.
But what use can we make of it? And to what extent is a defendant constitutionally permitted to look behind that curtain to confirm that his rights have not been violated?
what right? That's my whole point. In other words, there is a tip comes in, unsolicited tip comes in from the foreign country, the intelligence of the foreign country, and says, we have information that this particular website was used to access pornography. It comes to the FBI. The FBI says, we've had long dealings with this agency, and it's always been trustworthy and been accurate, and we intend to rely on it. They use that to trace down the computer in the United States. Now, my question is, that's not a joint venture under that hypothetical. And if that's not a joint venture, that would be appropriate, right?
If that's not a joint venture.
Yeah, okay, the joint venture would be is if the United States asked, do you have anything here, or helped it, or sent the name to them? How do you talk, how does a joint venture work?
Well, that's why Mr. Dugan is seeking to compel, because in this type of scenario, what we're talking about are long-term investigations of computer networks throughout the world and information sharing back and forth.
Well, how do you know it's information sharing?
Well, because of the search warrant affidavit that talks about the long history of cooperation between the United States government and this foreign law enforcement agency.
What plausible showing did Mr. Dugan make?
So the plausible showing he made is that with respect to the tour, even in the search warrant affidavit, it makes clear that the way that the Tor browser and the Tor network works, there is no ordinary investigative means that can be utilized to identify an IP address. So it begs the question of how is a foreign law enforcement agency able to identify this IP address if, as is set forth in the affidavit, there was not a accessing or invasion of a computer device in the United States. There must have been, given the way that the Tor browser works, and the United States spent pages in the affidavit talking about Tor and its complexity, there had to have been some type of action by the foreign government that Mr. Dugan should be allowed to investigate. For example,
Why? They're going on to the Tor network in their country, and they're going in there and they see a bunch of different sites that have accessed child pornography, and they copy down the numbers and provide that information to other countries for enforcement of their laws. The question is, they're in a totally different country, they're going on to the internet. It's not impossible to get into Tor. I think it's just hard. I mean, the fact they did get into Tor, and they did discover computers that have access to Tor, and they didn't have to go to the American computer. It appears on the site in Tor where the access is shown into the Tor network, and you're asking us to order an investigation into this other country's intelligence gathering.
not exactly, not exactly. Tor is a little more complex than that.
I know, but we have to be focusing on the role of the FBI. And the FBI or Department of Homeland Security, I don't know which one it was here, but our law enforcement agency, the question is, were they involved at all in getting this off the Tor site? And the answer is no, they received the tip from this country. That's what the affidavit says.
But to the extent that there is a relationship between the FLA and the FBI, to the extent that there are information sharing protocols, to the extent that there is an agreement between the countries on how they will do this so that the information can be obtained in a way that it's useful to the FBI, Mr. Dugan is entitled to know that. And I would argue that he's entitled.
You're saying he was entitled to know that when the affidavit was presented to the magistrate judge?
What
The
I'm,
magistrate judge had to tell him to go back, and give him a 65-page affidavit, and he's got to tell him to go back and give him more information?
what should have been included in the affidavit, Your Honor, is information that tied this case more directly, this affidavit more directly to Mr. Dugan.
Well, it did tie directly to it.
Well, only to the extent that there was a tip that on a particular day, a single occasion, that an
And the
IP
issue was
address.
probable cause.
The issue was
To believe
probable
that it
cause.
was him, and the magistrate judge was satisfied, and the district judge was satisfied, without going into all this background and investigation of the investigation.
But he makes a
You're
plausible.
asking for quite a bit.
He makes a plausible showing by arguing that it's material to him because to the extent that there is a joint venture and to the extent that the foreign government is doing at the United States
You're saying
request.
there's a joint venture, and in that Sanders case, we said, well, that's just guesswork. And we rejected that summarily.
I understand, but because of
And
the.
that's published,
It is,
aren't you, you're stuck with it.
I am stuck with it, but I'm distinguishing it on the basis that Mr. Dugan's circumstances are different because Mr. Dugan is arguing that but for a joint venture between the foreign law enforcement agency and the United States, there could not have been a warrantless search of his computer by a foreign government, and therefore.
Well, there was no evidence that the foreign government went into his computer. The foreign government said, basically, that they had access to the Tor site and discovered that this computer site accessed the pornographic site. And it was the local law enforcement in the United States that used the computer site to trace it down to the defendant in this case.
The foreign government was not that specific, and the affidavit is not that specific. We do not know whether the foreign law enforcement agency was using software that allowed it to identify the IP address. We do not know whether the foreign law enforcement agency was using some type of computer code that it had embedded in the site that would allow it to send information to people accessing the site and then retrieve back from that the IP address. We don't know whether the foreign law enforcement agency installed malware that allowed it to get to that result. The problem with that is that in the United States, a warrant would have been required for all of those things. Specifically.
But I thought you agreed that the foreign nation is not subject to our Constitution.
Unless there's a joint venture between.
Well, you don't have any evidence that the United States participated and said, we suspect this guy, help us out. Or that they provided a name to the foreign agency. The information is that out of the blue, this foreign agency informed the United States of this information, simple information. This computer site accessed Tor, and which had child pornography. And that's what they revealed, and that's it, right?
That's all that they revealed.
Yeah.
But
And under, because you keep going back to this warrantless search by the foreign agency, but, I mean, we have a case, I think it's Abu Ali, it clearly says that they are not subject to our constitutional criminal procedures.
Unless there's a joint venture. What Abu Ali says, and goes back as well to the Stokes district, the Stokes case from the Seventh Circuit. If United States agents substantially participate in an extraterritorial search of a U.S. citizen, and the foreign officials were essentially acting as agents for their American counterparts, or the search amounted to a joint operation between the American and foreign authorities, the Fourth Amendment generally applies. These types of investigations are just that type of investigation, where there is an extraterritorial investigation by a foreign government.
The United States conducted its investigation entirely in the United States, and it acted on a tip received from a foreign government. It did not request the foreign government for that information. They have shared information as it arises, but there was no participation by the FBI or Homeland Security into seeking this information out. It was discovered by the foreign government on the internet, and the information provided by the FBI and the Homeland Security, acted on it. From that point, the affidavit describes how they narrowed it down to a particular home, and the search warrant, of course, uncovered it.
I respectfully disagree with that position.
Well, tell me where it's wrong.
Well, it's
Show me
wrong.
in the affidavit, show me where.
Well, that's the problem. The affidavit does not contain that information. All the affidavit says
Well,
is.
where are you getting your information then, that you think that we were acting as, that the foreign government was acting as our agent, or there was a joint venture? What evidence do you have of that?
So the affidavit itself talks about the long history of cooperation and information sharing, including in child sexual abuse material or child pornography type investigations. This is a circumstance where there was information sharing about online electronic activity involving an IP address in the United States. And I know the court is taking a broad view that
So are
this-
you suggesting that every investigation that the United States, during these corporation, when they're cooperating with these foreign nations, are you suggesting that all of those are joint ventures?
I'm suggesting that the defendant is entitled to discovery to ascertain whether that joint venture exists or not. And that was completely foreclosed in this case because the court, the district court, took the position that unless Mr. Dugan could affirmatively come forward with information which is known only to the government and held only by the government, then he cannot raise a challenge here. And if he can't under these circumstances, then I would posit that it never could happen. And if it never could happen, then we're in a situation where a foreign government can always just provide information to the United States that says, this is good enough for us, it should be good enough for you, and our government in turn relies upon it and tells a defendant exactly what Mr. Dugan was told here. You have to trust us that the underpinning of this case, because this whole case rises and falls on this tip.
Okay, why don't you wind up? I notice we're quite over.
Yes, thank you, Your Honor. I would wrap up by saying that this court should distinguish Mr. Dugan's case from the Sanders decision. And in doing so, it should reverse his convictions, and it should reverse the decisions denying his motion to compel and his motion to suppress.
Thank you. All right, Ms. Wilson.
Good morning. May it please the court. Holly Wilson on behalf of the United States of America. This court should affirm the district court's decisions denying the motion to compel and motion to suppress. This panel's decision in United States versus Sanders is controlling and dispositive on both of the discovery disputes at issue here. It seems that this court is most concerned with the motion to compel, so I will begin there. In light of Sanders, the court should find that the district court that there was no error and no abuse of discretion when the district court denied the motion to compel. The defendant's entire argument below that there was a joint venture wherein this foreign agency hacked into his computer was just a guess. It was unsupported by any evidence.
Well, I'm not sure she alleges they hacked in. As a matter of fact, the affidavit contradicts that the foreign agent did not access the American computer at all. They just provided the information that they discovered. I think her argument is because they have a history of exchanging information, that is in and of itself a joint venture that means that the United States is charged with all violations of American constitutional law by the other country.
And there's absolutely no evidence of a joint venture. The representations in the affidavit that there is a history of cooperation and information sharing merely serves to bolster the reliability of the foreign law enforcement agency. And cooperation alone is not enough to establish a joint venture. The Abu Ali case that Judge Benjamin mentioned requires that there be some showing of active and substantial participation by the United States in order to get to a joint venture. The evidence that was before the district court overwhelmingly goes the other way. The affidavit and Agent Fleener's testimony during the pretrial motions hearing both established that this was a completely independent investigation conducted by a foreign law enforcement agency. He actually testified that he had not spoken with the foreign law enforcement agency, and he also testified that he didn't have any more details beyond what had already been disclosed in discovery. And I want to...
The he there is the affiant?
Yes, Your Honor, that would be Agent Fleener. I apologize for any confusion.
Real quick, on the, why would this Ritchie not be applicable here, the lower plausibility, as to her motion to compel?
I apologize, Your Honor. I'm familiar are you talking about the Ritchie case?
Yes, she's this lower plausibility standard, this exception, as to the motion to compel.
Oh, I understand, Your Honor. Even accepting this lower plausibility standard, you have to have facts. There have to be facts in evidence. And this court's decisions in Caro and in Sanders both stand for that proposition. Conclusory statements are not enough. And that's for good
Well,
reason.
how are they supposed to get the facts if you won't give them to them? Or help them gather them?
Your Honor, the defendant in this case had everything that he needed to go out and get facts. The tip documents were disclosed 6 months prior to the pretrial motions hearing. He was aware of the identity of the foreign law enforcement agency, and he was aware of the tip documents. He could have gotten evidence from a expert on computers about the likelihood of an intrusion into his computer. He could have gotten an expert that said that this country has a history of working in a joint venture with the United States and intruding on people's civil liberties. None of that was here. And that makes this case actually even easier than the Sanders decision. In Sanders, the defendant at least had expert declarations about the likelihood of an intrusion onto his computer. Of course, the defendant does not have to take the United States' word for it, and he didn't in this case. But there was nothing beyond his attorney saying, well, I did some independent reading on the internet, and that's why I think this. It was just a hunch. There was no evidence. There have to be facts in evidence for the district court. And the facts that were before the district court overwhelmingly supported the conclusion that there was no joint venture and that the United States had not participated at all and that there was no intrusion onto a U.S. computer. Because of that, the defendant has not met his burden under Brady and Rule 16, and the district court's decision on the motion to compel should be affirmed. I apologize.
No, go ahead.
If there are no further questions on the motion to compel, I'll just briefly touch on the motion to suppress. Sanders is very clearly controlling on the motion to suppress and the issue of probable cause. The court in Sanders decided that there were several pertinent facts that established, quote, beyond doubt that probable cause existed. All 5 of those facts, and there's a bullet list in Sanders, which I know this court is familiar with, all of those 5 facts are found in the affidavit that we're dealing with here today. If this court were to find that there was no probable cause, the good faith exception does apply. And as a threshold matter, I will just state that the defendant has waived his argument with respect to the good faith exception. Below, he merely argued that the agent had misled the magistrate. He did vehemently contest probable cause, but that was a general objection to the affidavit. Nowhere in the record below does it show that he contested that or made an unreasonableness challenge on the good faith exception. By all accounts, this affidavit is strong. It is 52 pages
The
long.
district judge ruled specifically on good faith.
Yes, Your Honor. Yes, Your Honor. Judge Goodwin did rule specifically on good faith.
He dealt with it. He thought he had enough to have to deal with it.
That's correct, Your Honor, and that's because the defendant below made the argument on misleading the magistrate. The defendant below did not make the argument that probable cause was so lacking that it would be unreasonable for an agent to rely on it, on the affidavit, on the search warrant. The arguments between no probable cause and unreasonableness, they're similar, but they are distinct.
She says that the affidavit here is different than the one in Sanders because Sanders, I believe that's the argument that she made earlier, was that the affidavit in Sanders says that there was that the foreign government had a warrant, whereas here there was not.
Your Honor, the affidavit here is almost identical to the affidavit in Sanders. Ms. Morgan is correct that our affidavit does not say that a warrant was obtained. However, it says that it was lawfully obtained in the foreign countries, under the foreign countries' laws. And I'll submit, and while it's not in the joint appendix, the tip documents say that there was a warrant, 2 warrants, actually. So I don't believe that there's any meaningful distinction with respect to probable cause between the Sanders affidavit and the affidavit we're dealing with here today. If the court doesn't have any further questions, I'll just close by saying that this court should affirm the district court's decisions.
Thank you. Ms. Morgan?
I'd like to address first the government's position that Mr. Dugan could have obtained discovery. Here, I acknowledge that Mr. Dugan was supplied with the first 4 pieces of information that he sought in his motion to compel. He sought information about the identity of the foreign law enforcement agency, and he sought information about the identity of the target website, and he obtained that. But I disagree that he either had the obligation to or could have obtained the other information that he sought in his motion to compel, and that's sections 5 through 11 of his requests for additional information. He was specifically seeking information that was in the government's control about what it was that tied him to the IP address, what records, reports, files, logs, notes that they had that connected him to that. He wanted to
You
know
mean what tied the
the
number?
IP address.
IP address? What would you expect? I mean, the IP address is connected to a computer, right? The computer issues that as metadata, and so the only question is to identify the location of the computer, right?
That is what an IP address ultimately tells you, but
Yeah.
the foreign government in this case advised the FBI and Homeland Security that it had information that connected him to this
Not him,
target
it connected
website.
an IP address to the Tor.
And he said, what information is that? What information did the foreign government have, and how did they get it?
I thought you said you were asking for information in the hands of the federal, our government.
What I'm saying is that to the extent that they have it, or to the extent that they can get it,
I mean, the
it's
information,
their
the
obligation to
affidavit-
share that.
The affidavit reports the information received, which was an IP address and its connection to child pornography. And it said it was obtained lawfully under its own laws, and it was obtained without access to a United States computer. Now, that information, the IP address was applied to the United States, and then our law enforcement agencies linked it to the defendant, right?
That's right.
And there's no
Using
mystery
the-
about that. Is there how they did that?
No, they did that using the affidavit that he is challenging and the motion to compel that he attempted to file to try to look behind the curtain and see what relationship is there between the United States and this foreign law enforcement agency. What agreements do they have about the sharing of information regarding the searching of electronic devices and what each country will do in those investigations that would allow him to establish the
Okay,
existence
that
of
goes
the
back
joint
to your
venture?
joint venture argument.
It does.
I thought you were
It
asking
does.
about how they determined that the IP address was connected to the defendant.
That's what he was asking for.
Okay, but
He was
that
asking for
doesn't have anything to do with the joint venture. That has to do with how the Homeland Security linked the IP address to the defendant.
No, Your Honor. The foreign government gave a tip that said it had linked the IP address that eventually our government linked to the defendant.
Right.
To this website.
Right, I understand that, but you were complaining about not receiving evidence from our government about how it linked the IP address to the defendant. That's what you said.
Yes.
All right. How the IP address was linked to the defendant is a domestic investigation issue. And it's not hard. I mean, it's done all the time. They linked it to the, geographically, to a house, and then they got a search warrant.
But he also challenged, Your Honor, the linking of the IP address to the target website, and he
Well, that's
sought
a-
information about that. And he sought information about the connection as to these investigations between our government and the FLA. And he did that because it's material to his defense.
How
to
do
be-
we have control over the investigatory agency in the foreign country to tell that country to produce documents? Because the affidavit says the only information he received was, and it's all quoted there in the affidavit, is the IP address was linked to the Tor, which had pornography on it. And didn't even suggest how to use it. It just said, this is information, and we ran with it.
To the extent that our government doesn't have it and can't produce it, I concede that they would not have it to produce it. But what they would have would be agreements between our government and the FLA about how the countries will cooperate and collaborate and share information about surveillance and monitoring of electronic communications originating from this country, which is what Mr. Dugan asked for below. They also would have information, in addition to agreements, about prior history of collaboration between the FLA and our government's agencies relating to policing of illicit activity on the internet. And they also would have information about the specific technique that was used by the FLA to support that the IP address accessed the targeted website.
But cooperation and collaboration and sharing is not a joint venture.
Well, I would
What
argue.
you're asking for, cooperation, collaboration, sharing, how is that a joint venture?
I would argue that depending on what was revealed by the discovery that should have been produced, that Mr. Dugan could have established that this joint venture existed. It's a very circular problem for him in that he's obligated to allege the existence of a joint venture with sufficient specificity to create a plausible showing. And he's attempting to do that by referring back to the affidavit about the long history of cooperation between the countries. But he can't get at the underpinning to establish what the full extent of that relationship is and what that collaboration is and what that, what we would argue agency relationship is between the two of them, because he's not permitted to obtain it because he lacks the specific facts, which he can't get.
I think your red light's on.
Oh, I'm sorry, I didn't see that. Thank you.
We
Your
don't
Honor.
give tickets, but on the second try, we do normally.
Thank you, Your
I
Honor.
understand you're court appointed, is that right?
That's correct, Your Honor.
We're very much appreciate that. I mean, your client appreciates it, but it's also very important to the system, as you know, and you've done a fine job. And we'll come down and greet counsel, proceed to the next case.
Thank you, Your Honor.
We're going to take a short recess. Come down and greet counsel and take a short recess.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated, please. Next case we'll hear this morning is Barnhill versus Garland, and Mr. Renner will hear from you first.
Thank you, Judge Niemeyer. Richard Renner here from Raleigh, North Carolina. With us in the courtroom is Lisa Barnhill, and I want to start with page 14 of the Department of Justice brief, where they make this statement. Barnhill attempts to recast the narrative, making herself the victim of discrimination and retaliation. I agree with that statement, and it is precisely when the two sides have different narratives about the same body of evidence that we have juries make the final decision. Barnhill's narrative explained how her black male supervisors, Dave Downing and Joseph Shepard, wanted her to be seen but not heard and excluded her from group supervisor meetings. After she filed her EEO complaint in September of 2015, the special agent in charge, Keith Brown, joined them in scorning Barnhill and subjecting her to hostile management review and then isolation and abandonment in a temporary duty assignment. This temporary duty assignment required Barnhill to use her government vehicle every Monday, drive 8 hours from Little Rock, Arkansas, down to the SAC headquarters in New Orleans, and then come to the office and perform no substantive duties on Tuesday, Wednesday, and Thursday, staying at a hotel at government expense, and then on Friday, driving 8 hours the whole way back to Little Rock. Barnhill called it highway therapy. The supposed justification was to protect the management review process, but it's particularly fishy that this TDY began after almost all the interviews in that management review had already been completed. Only
Wasn't
one.
there also a complaints against her for a hostile work environment, and that's their explanation as to why they did the temporary duty assignment?
If you're talking about Pamela Lee's complaint, that was filed after this TDY was put in place. It was put in place with the November 2015
Well,
memo.
not the EEO complaints, but there were complaints to management, the supervisors, that from employees that she was of a hostile working environment, that she was harassing them.
Well, there had been similar complaints like that before June of 2015, when the ASAC, the supervisor, Joseph Shepard, had initially announced to Barnhill that she would be placed on a management review. But at that time, Brown said no, he wasn't going to authorize it. He was going to try to work things out. But then after she filed the EEO complaint, this is when all hell broke loose. And she got put on the TDY, and the management review actually got underway without any memo to Barnhill explaining the reasons for it. And to my knowledge, the record does not substantiate that between June and November, there were any specific additional employee complaints. What there was a declaration from ASAC Lemons, who was not Barnhill's immediate supervisor, but after the close of discovery in the district court, the Department of Justice put forward his declaration saying he asked Brown to commence the management review based on hearing some complaints from employees. Those complaints were not specified, and we don't know if they occurred before or after June, when ASAC Shepard had asked for the management review. But what did change between June and November is that Barnhill filed her EEO complaint and Brown's attitude changed. In June, he said he was trying to work towards resolution. That's at page 835 of the joint appendix. But later, in October, he's aware that there are people going to be filing EEOs if they hadn't already filed them. That's at joint appendix 226. The
But
filing of
doesn't
the
she on October, I understand she files her EEO on September 22nd, but isn't this annual performance review done, and the negative annual performance done like October the 12th?
Yeah,
Before Brown gets notice from the Oh, that she filed a complaint?
Well, there are actually two performance reviews that ASAC Shepherd had prepared. And we don't know, at least Brown and Shepherd have not stated what is the date on which they learned about the EEO. But Brown does make very clear that normally the EEO office will notify him when there's an EEO proceeding commenced in his division.
I thought that was November 6th, that's when he received the official.
That's when he received the official written notice. But when we asked him directly when he actually learned about it, his answer was, I don't remember. And he testified that normally he does get notified by the EEO office. And in this case, Barnhill specifically asked for alternative dispute resolution, which would involve the EEO office asking the supervisors, would you like to participate in ADR? And the EEO office did not record the date when they made that request to the supervision. But if you would compare,
When did Lemons request the management review?
I recall him saying October. I don't recall a specific date.
And he requested that based on multiple complaints from employees, right?
That's what his declaration says that we got after the close of
Is
discovery.
there anything to suggest otherwise as to him?
Well, there is the testimony by Shepherd that in this division, everything went through the SAC. Any personnel issues, they're always talking to the SAC. That's Keith Brown. And I think that supports an inference.
SAC is the special agent in charge.
SAC is the special agent in charge, yes. The leader of the division in New Orleans.
Of the division.
New Orleans Field Division.
Who is
in
that? Who is by name?
Keith Brown.
Well, I know, but I'm talking, my question to you is directed by Lemons. Brown said Lemons initiated the management review, and Lemons said he initiated it because of the numerous complaints from employees about management style and the difficult work environment and so forth. And so they conducted that management review. And my question is, what do you have to impute to Lemons, anything other than those complaints?
Well, we don't have to impute anything to Lemons
I
because it
didn't
is.
ask you to argue the case. I asked you factually, what is there imputable to him?
Well, he is a management official that serves under Brown, and he would follow Brown's directions.
Except Brown said the management review is initiated because of Lemons' request.
It was Brown's decision.
Yeah.
He owns it.
I understand that. But the request came from Lemons, and then Brown had to act on it or not.
Yeah, this is really kind of a topsy-turvy version of Staub versus Proctor Hospital, right? In Staub,
You know, when I ask you a factual question, I'd like to get an answer about what's in the record, not an argument. You can argue the facts.
well,
but,
there is no direct evidence. Lemons does not admit to knowing about the EEO proceeding or wanting to reprise against it. But I think there are grounds to infer otherwise. And that's the issue here at summary judgment, is whether or not there's a basis for a jury to make an inference of animus. And to get back to Judge Benjamin's question.
But I don't think below that your client, you made allegations that Lemon knew about the EEO complaint.
We don't have direct evidence, but we did certainly argue that there is a basis to make an inference of reprisal against the employer.
Except,
And that is our standard.
It's hard to draw an inference when there's no direct evidence that he knew any of this, and he was acting affirmatively on complaints received from numerous employees. And that's why they conducted the management review, and it had to be of a certain level of significance because they wanted to conduct it without her present in the department, and that's why they gave her the temporary duty down in New Orleans, in Louisiana. But it seems to me it's fairly significant, is it, that Lemons initiated that undisputedly based on complaints.
Well, as to the legal significance, I think we can dispute that because
Well, whether you can, that's the question. Did you?
yeah, we very much allege that it was Brown's decision and that he was affected by animus against the EEO complaint. And if you would compare the summary chart of the October 12, 2015 performance rating at Joint Appendix 669 with the October 27 version at Joint Appendix 457. You'll see a very stark contrast where Joseph Shepard goes from rating Barnhill's performance as exceeds expectations with outstanding ratings on 4 critical elements to a rating that is substandard, rating her at or below expectations. And his deposition testimony says that he could not identify anything that happened between October 12 and October 27 that would justify such a stark change. The Department of Justice would have us believe that that October 12 performance appraisal was just a shell that he was working with, but that doesn't explain why he would submit it by email to the clerk at Joint Appendix 718, or why he would show the exceeds expectations rating of Barnhill at Joint Appendix 719. You know, from that stark change, downward change in her performance appraisal, there's more than adequate basis for a jury to infer that he did learn about the EEO sometime in that range, and it caused this dramatic downturn in the performance appraisal, especially when the Department of Justice has no other explanation for that
I'm
difference.
still struggling with how do you get around, the official notice was sent to Brown on November the 6th, so, which would have been a week or two after the annual performance review.
Right. Well, the September 22 complaint was noticed to the agency about her EEO complaint. And on Monday, I filed a notice of supplemental authority about the Jones versus Bernanke decision from the DC Circuit that makes clear that causation can be inferred from the employer's knowledge and the subsequent adverse action. And if retaliation can be inferred, then so can knowledge. And especially where Brown and Shepard both deny remembering when exactly it was that they learned, and Shepard admitting that if he got verbal notification from Brown about the EEO, there'd be no record of it. And Brown testified that he normally did get information when EEO complaints were filed. All that together would support an inference that they got verbal notification of the EEO complaint in October before the October 27 performance evaluation. But even without that, the way in which they treated Barnhill afterwards with the highway therapy, and then Brown's decision to go up to Little
Let me
Rock.
ask you about you. You refer to that pejoratively. I thought it was explained to her, and she seemed to accept it, that while they're conducting a management review of her department, that she shouldn't be present there for a lot of obvious reasons, and that they wanted her at some other location temporarily while they conducted that investigation. Isn't that what was told to her?
She received a written memo. It was not discussed with her, and she did not accept it. She definitely made a complaint saying it was retaliatory. And the fact that the management review report was issued on January 12, 2016, and they maintained the highway therapy for 6 weeks after that, or maybe 4 weeks after that, a whole month, undercuts the claim that it was to protect the management review process.
But you all don't, I believe below, you don't dispute under that this is just a pretext.
I didn't hear precisely what it is you say.
Do you dispute that this was as a pretext, this argument about moving her because of the other complaints that they received?
I do recall that the Department of Justice claimed that we did not raise it below, but in fact we did. And in my reply brief, I cited the places in the record where we raised it in the court below. I'll see, in my rebuttal argument, I'll find that and get that to you. In addition to the summary judgment issue about the retaliation and the hostile work environment, we also have claims that were dismissed at the pleading level. In particular, her non-selection claims. Within weeks after filing the EEO complaint, Brown and Shepard submitted negative performance reviews of Barnhill. Those were submitted to the career board, a career board that includes officials who know about Barnhill's EEO complaint. And despite...
But did you plead that below?
We very much did.
As to who was on the career board that knew? about the EEO complaints?
We definitely pled that the assistant director and the EEO director had knowledge. We also alleged that the special agents in charge had knowledge, and they are represented on the career board, even though the agency has not told us which specific SACs represented the SACs on the career board. That is information we would want to get in discovery. But we did allege that the career board members, including the assistant director, the EEO director, and the SACs, the special agents in charge, their representatives all had knowledge of Barnhill's EEO complaint. And even if they didn't.
And they were on the career board to make the decision?
I couldn't hear you.
And they were on the career board?
Yes. Now, the EEO director was a non-voting member of the career board, but still a member and still had knowledge and could still share that knowledge with the other career board members. And SAC Brown told Barnhill that he told SAC James Schroba that Barnhill should not be given any promotion. That's in our amended complaint. And that is knowledge by another SAC. And these SACs, they rotated in and out of the career board. We don't know which of the SACs it was. Obviously, that's information we'd want to get on discovery. But the fact that she could not get promoted, but an employee who had never served the required time at headquarters was selected for the promotion in Seattle that Lisa Barnhill applied for. She met the qualifications for that position and was not selected. That's another deviation that would justify a finding of discrimination. There was something
I see
fishy in
you've
those
got
not-
some, you got some rebuttal time that you're.
Yes, thank
red
you very
light's on.
much.
Yeah, all right. Mr. Fuchs?
Thank you, Your Honors. Your Honors, and may it please the Court, Assistant United States Attorney Yuri S. Fuchs, on behalf of Defendant Appellee.
We're all the way across the room, so keep your voice up.
Okay, sorry, Your Honor.
That's better.
AUSA Yuri S. Fuchs on behalf of Defendant Merrick B. Garland. Your Honors, in October of 2015, the DEA launched a management review of Plaintiff Lisa Barnhill and put her on a temporary detail following repeated and long-running complaints from plaintiff's subordinates that she was discriminating against them, subjecting them to unprofessional conduct, and otherwise creating a sexually and racially hostile work environment at the DEA's Little Rock, Arkansas office. The DEA's investigation and temporary detail represented a common-sense solution to investigate allegations of a hostile work environment and remove plaintiff from a fractious situation that she created with her subordinates. The wisdom of those measures was borne out by the results of that investigation in a later EEO proceeding that
Is that
concluded
when she started driving to New Orleans? Is that what?
the temporary detail,
You're
yes,
getting
Your
at?
Honor. Yeah,
Temporarily, yeah. That's what he called the highway therapy. Where did that term come from?
that term is plaintiff's acknowledgement that it's hearsay testimony that she heard from another individual whose testimony was not in the record and that
So
he
was a-
supposedly.
That was a witness in some deposition referred to that.
She referred to it in her deposition as highway
referred
therapy.
to it.
Yeah,
Okay.
and when probed on where she actually got that term, plaintiff made clear that she heard it from another individual who heard it from Sac Brown.
So it came from the plaintiff.
Yes.
All right.
Yeah. The wisdom of the DA's measures was borne out by the results of the management review investigation. In a later EEO proceeding, concluded the plaintiff had indeed discriminated against the subordinate and created a hostile work environment. Even after this, the DA allowed plaintiff to continue working in Little Rock at a separate office once her temporary detail expired, where plaintiff continued to work until she voluntarily transferred to a separate DA office in 2016 and until she voluntarily retired from the DA in 2021. Disagreeing with the management review's conclusions and those of the separate EA proceeding in the court below, plaintiff attempted to refashion every work-based action she disagreed with from 2015 onwards as being the product of discrimination against her as a white female, retaliation for protected activity, and the product of a retaliatory hostile workplace. Plaintiff's attempt at revision did not succeed, and for good reason. Indeed, while plaintiff notes that there's a fissure here in whether or not she's recasted or not recasted, the point is not that plaintiff recast the narrative, it's that the narrative does not support her claims on the pleadings or on the record evidence as the district court.
What's your best argument for, on October the 12th, her draft annual performance review, I think it was excellent or excelled or whatever, and then on October the 27th, his argument is that someone must have found out that the EEO complaint was filed, and then on the 27th of October, there was this negative annual, or, well, an employment review that it was changed.
I take your point, yeah. A couple points to that, Your Honor. So one, this court has made clear in Roberts and other cases that actual knowledge is the benchmark for showing causation in a prima facie case of retaliation. As the district court correctly held, there was no record evidence of actual knowledge by A. Sack Lemons or Sack Brown, the individuals involved with the decision to initiate the management review. In Sack Brown's case, until November 6, 2015, there is no record evidence that A. Sack Lemons knew of plaintiff's EEO complaint at the time. And as to that performance evaluation, Your Honor, that was instituted by A. Sack Shepard. And as Judge Trenga correctly noted below, there was no record evidence that A. Sack Shepard somehow told Lemons or Brown at any point to confer actual knowledge upon them. And as to that performance evaluation, Your Honor, again, A. Sack Shepard is actually not the decision maker here. As per this court's precedents in Holland, what you look to is the perception of the decision maker, here Lemons and Brown. But even taking the point that there was some sort of change in the performance evaluation, A. Sack Shepard's deposition testimony, which was not controverted by plaintiff, actually explained that this October 12th document that they're pointing out is a shell. It doesn't have any rating comments. It doesn't have a signature. It doesn't have a date. And in fact, the record evidence shows that long before October 12, 2015, A. Sack Shepard was repeatedly critical of plaintiff's ability to lead her subordinates and had already started giving her negative evaluations for positions she was applying to well before her September 2015 EEO complaint. As the district court correctly concluded, Your Honors, plaintiff's narrative failed on the pleadings and then on the record evidence. As to plaintiff's discrimination claims, the district court correctly held the plaintiff failed to plausibly plead discriminatory animus by the relevant decision makers for any adverse
Now,
actions.
the district court wrote multiple opinions in this case.
Correct, Your Honor.
And what, there are three?
There are three, yes. So there is an initial dismissal order on plaintiff's first complaint. Plaintiff, in that dismissal order, Judge Trenga kicked out everything but the retaliatory hostile work environment claim and the retaliation claims based on the management review and the temporary detail. So he dismissed plaintiff's discrimination claims. He dismissed any claim that she had engaged in protected activity in June of 2015. And he dismissed any claims of retaliation unrelated otherwise to the management review or temporary detail. Following that, plaintiff repled her complaint to try to address those deficiencies. In a subsequent order issued by the court after discovery had closed, Judge Trenga dismissed those repled claims again. And as to the claims that he originally allowed to proceed to discovery, he then issued a summary judgment decision on granting defendant's motion for summary judgment on the remaining retaliation claims and the retaliatory hostile work environment claim.
So that was the third opinion.
Correct, Your Honor.
Now, did you all ever have an oral argument during the course of those proceedings?
We did, Your Honor, yeah.
Before Judge Trenga?
Before Judge Trenga, yes, Your Honor.
He notes one point that the parties waived oral argument.
On the motion to dismiss, I believe.
I don't know what it was.
Yeah, I'm struggling to remember too, Your Honor. On the
I
summary.
noticed that on the record here, you waived oral argument in the district court, and then you come down here and you won it.
No, Your Honor. So I would say it's on always appellant always requests whether something requires oral argument or not in this court. But I would note, Your Honor, that we actually did have a hearing below before the district court on the summary judgment motion, and I believe that's accepted towards the end of the joint appendix.
So there was a hearing.
Correct, Your Honor. As to plaintiff's retaliation claims, the district court correctly dismissed plaintiff's claims in part at the threshold, noting that plaintiff had not pleaded any protected activity prior to September 2015, and that any claims of her suspension and non-selection failed at the threshold because plaintiff did not plausibly plead that the decision makers for those actions, specifically the suspending official, Matthew Germanowski, or the career board, had actual knowledge of her complaint. And to that point, Your Honor, I'd like to respond to my colleague's point, where he said that he pled that the deputy administrator official and an EEO official knew of plaintiff's protected activity. We'd submit, Your Honor, that the district court found that what plaintiff had not alleged was that the majority, plausibly pled that the majority of the career board actually knew about her complaint. The EEO official is not a voting member. As to the remainder of the SACs on the career board, Your Honors, plaintiff's allegation was, upon information and belief, she speculated that the SACs talk amongst themselves and ergo would have talked about her EEO complaint. The district court correctly held the plaintiff had not plausibly pled knowledge by the decision makers based on that allegation. Plaintiff makes the argument that they actually didn't get the names of the SACs involved in the career board. Plaintiff got discovery on this. They got the meeting minutes of the career board meetings. And in fact, the record evidence shows that plaintiff, in her own deposition, admitted that it was a purely speculative allegation on her part that SACs talked about her EEO complaint. She had no evidence in support of that. And one individual who was deposed in this case, William Glaspie, who was a SAC and who had been on career boards, confirmed that he had never heard any kind of career board ever discuss an individual's EEO complaint. And the meeting minutes produced the plaintiff bear that out. Meanwhile, as to the remaining retaliation and retaliatory hostile work environment claims that proceeded to discovery, the district court correctly and ultimately granted summary judgment on those claims. As the district court correctly held, the record evidence did not demonstrate that the decision makers behind those actions had actual knowledge, as per this court's decision in Roberts, of plaintiff's protected activity. Plaintiff in his argument, plaintiff's counsel in his argument notes Sack Brown's testimony, "I don't remember." The record evidence here shows, and the only record evidence of Sack Brown's knowledge of plaintiff's EEO complaint is that he learned this in November 6th of 2015, well after Lemons had asked him to initiate a management review and Sack Brown began the steps to proceed with a management review. On summary judgment, it is plaintiff's burden then to cite to a contrary record evidence somehow disputing that Sack Brown did not know of plaintiff's protected activity on November 6, 2015. That record evidence was not submitted in the court below, and it's not cited to here either, Your Honors. And the district court also noted, assuming arguendo that the decision makers had actual knowledge, there were legitimate non-retaliatory reasons for plaintiff's management review in detail, namely that plaintiff's subordinates complained that it was untenable to keep working for her and that plaintiff needed to be kept away from the Little Rock office until plaintiff's supervisors could determine how to move forward following the conclusions of any management review. Plaintiff here attempts to argue that because the management review continued past the stamped date in her management review findings, which was January 12, 2016, that somehow that reflects retaliatory animus. Per this court's decision in Holland, and as the district court correctly held, to show pretext, you have to show falsity in the stated reasons for a decision. Sack Brown, in implementing the TDY, put forth two reasons. One, to allow the management review time to finish, but two, to also allow himself time to think and ultimately conclude what to do as a result of the findings of the management review. Indeed, his deposition testimony, excerpt in the joint appendix, explicitly notes that even once the management review ended, it did not mean that plaintiff's TDY would come to an end. And as we pointed to in our briefing, Your Honors, and as noted in the record evidence below, that January 12th, 2016 memo appears to have been stamped based on the date of the draft. Sack Brown's testimony, an uncontroverted testimony, is that he had left the New Orleans division before that management review was ever concluded. So he actually ultimately did not see the findings while he was still the SAC in the New Orleans field office, and it is his testimony, as confirmed by a declaration from Daniel Comeau, the plaintiff did not move to strike in the court below, that the signature on that management review is not Keith Brown's, Daniel Comeau's, further emphasizing that even separate from the other basis that Sack Brown gave for the temporary detail, he did not ultimately learn of the findings of the management review while he was still the SAC of the New Orleans field office. On appeal, Your Honors, the plaintiff asked this court to reverse and remand for a jury trial, overlooking the implausibility of her allegations and focusing on immaterial asides as to summary judgment. The plaintiff has no rejoinder to some crucial points in the district court's decisions below. Plaintiff has no rejoinder to the fact that she never pleaded any kind of plausible discriminatory animus by various decision makers, namely suspending official Matthew Germanowski, Sack Brown, or the career board. The plaintiff has no rejoinder to the fact that she did not plead actual knowledge of her complaint by a majority of the career board or by suspending official Matthew Germanowski. And plaintiff does not dispute that her subordinates' complaints regarding her were long-standing and long predated any kind of protected activity. Plaintiff argues that it is somehow fishy that those complaints were not acted upon before, but Sack Brown well explained his reasons for doing so in his deposition of testimony, excerpt in the joint appendix. As Sack Brown explained, he wanted to resolve the concerns of plaintiff's subordinates informally, but by October 2015, he was hearing from ASAC Lemons that it was untenable to keep plaintiff in her position as a diversion investigator in the Little Rock office. Your Honors, unless you have any further questions, I'd like to request that this court affirm the district court's holdings below, granting defendants' motions to dismiss and motion for summary judgment, while rejecting the plaintiff appellant's request for costs on appeal.
Thank you, Mr. Fuchs.
Thank you.
Mr. Renner?
Judge Benjamin, it's on page 25 of our reply brief where we cite to electronic case file docket number 56, pages 11 and 12, where we raise this issue in our opposition to summary judgment in the court below. Mr. Fuchs says that what happened to Lisa Barnhill was due to long-standing complaints from her subordinates, but we note that in June of 2015, when Barnhill's own supervisor, Joseph Shepard, asked Keith Brown to authorize a management review, he refused. And Keith Brown said at that time that he wanted to try to work things out. After she files the EEO complaint in September, then things change. And Brown specifically noted that he was aware that people are going to file EEO complaints.
Was there a complaint filed against your client by an employee for sexual harassment or racial discrimination?
Not sexual harassment, but yes, for racial discrimination, and that was filed after.
When was it filed?
It was, I believe it was filed in 2016. It was after Keith Brown went up to Little Rock while Lisa Barnhill had to be in New Orleans, and he specifically asked Barnhill's subordinates to file EEO complaints against her. It was Brown's initiative.
Well, apparently that's in response to their serious complaints, and he says basically file a complaint. In other words, when you come up to somebody and say, she's been doing this, she's been doing that, but my question is, when was she found? She was found to have discriminated, right?
Well, they used the management review report to make.
My question is, she was found to have discriminated, didn't she?
The Department of Justice did make that final agency decision, yes, relying on the management review.
Well, doesn't that confirm the earlier complaints that all these employees were making were legitimate?
Lisa Barnhill has a right to go to trial.
I understand, but I asked you a different question. I didn't ask you to argue. You keep anticipating where I'm going. I'd like to know what the record shows in this. Apparently, these complaints had been ongoing. Isn't that right? The record shows that?
Only since Pamela Lee got to the office.
So your suggestion is that an employee instigated all these complaints by other employees?
Not quite that direct. Joseph Shepard gave Lisa Barnhill outstanding performance evaluations in 2012, 2013.
That doesn't preclude discrimination. Somebody can be a very good carry out performance and whatever, carry out the job, but can be terrible to the employees. And so the question here is, when does the record show that the complaint started?
Our contention is it was around 2013 when Pamela Lee arrived. And Lisa Barnhill and Joseph Shepard were in disagreement about how to evaluate and manage Pamela Lee's performance. And it was out of that.
It wasn't just Pamela Lee, it was other employees too, right?
After Joseph Shepard started
Was it
deviating.
other employees, right?
There were other employees who complained.
Okay, that's my question, right.
There were also other employees that praised Lisa Barnhill, and the management review never interviewed them. Did not interview the witnesses that Lisa Barnhill put forward to say, this is a unique situation in Little Rock that has been stirred up by Joseph Shepard deviating from the chain of command to undermine my supervision of the office.
Wasn't it in 2012, I think is it Geary or somebody else complained against her to Shepard? In 12,
yes.
Kelly Geary, I think is her name. So that was before, so it's not just Lee, it's others that were complaining as far back as 2012.
Yes, and in my.
Well, I thought you answered my question and they didn't start until 2013.
I stand corrected on that, but even in 2012, Joseph Shepard gave Lisa Barnhill an outstanding performance rating and assigned her to supervise the Jacksonville office.
I understand, that's argumentative. My question is, when did the complaints start? And the outstanding performance doesn't necessarily address whether she discriminated against people.
Well, I think this exemplifies how if you look at only one side of the evidence, it supports one conclusion. But there's a body of evidence here that supports different conclusions, and that's why this case needs to go to a jury.
But wasn't she like relieved of her supervisory duties in 2014 following some of these complaints?
Not in Little Rock. She was in Jacksonville, and she found out about it from a subordinate instead of from Joseph Shepard, which was quite unusual.
So I guess my question is one of the things you have to be able to show is that she was performing satisfactory in her job performance, and that doesn't seem as if she is.
Well, I think the declarations from Louis Laharza and Melissa Nannon undercut that management contention. And they never interviewed these two witnesses in the management review. And if they conduct a one-sided management review and it leads to the final agency decision in Pamela Lee's case and the discipline against Lisa Barnhill, Staub versus Proctor allows Barnhill to connect a causal chain from the employer's agent acting with discriminatory animus.
Okay, I see your lights out. Thank you, Mr. Renner. We'll come down and greet counsel and proceed on to the next case. Hassan versus Garland. And Mr. Diskin, whenever you're ready, we'll hear from you.
May it please the court, Daniel Diskin for the petitioner Ansar Hassan Hussein. The Board of Immigration Appeals grossly abused its discretion when it denied the timely motion to reopen that the petitioner filed with the agency below following his marriage to his U.S. citizen wife. Additionally, the agency also erred in its earlier decision dismissing his appeal from the decision by the immigration judge. Starting with the board's denial of his timely motion to reopen, the agency incorrectly determined that he failed to present clear and convincing evidence that he had entered into a bona fide marriage with his U.S. citizen wife. In reaching this conclusion, the agency either gave short shrift or entirely ignored critical evidence that was produced by the petitioner in support of his motion to reopen.
What did you just say the standard was? I didn't think that was the standard. That to reopen, you have to provide clear and convincing evidence indicating a strong likelihood
Correct, Your Honor. Clear and convincing evidence indicating a strong likelihood.
that it was bona fide. Not that the marriage was indeed bona fide, but just a strong likelihood to open up the rehearing.
Correct, Your Honor. That is a correct, precise formulation.
And the BIA did not use the strong likelihood standard, did it?
I don't think, correct, Your Honor, I don't think it followed the correct standard in this case.
Its own standard.
It didn't follow its own standard, Your Honor, correct. The evidence
So where
truly.
does the use of discretion standard come in then?
Well, this court reviews the agency to see if it abused its discretion. But one of the things that this court will look to is whether the agency followed its own case law. Another thing that the court should look to is whether, even if the agency followed the correct standard, which I don't think it did in this case, whether it adequately grappled with the evidence. So if the agency either doesn't follow the correct legal standard or doesn't follow its own case law, or alternatively, if it doesn't meaningfully address the evidence that was presented with the motion, either one would constitute an abuse of discretion. I do acknowledge that, you know, an abuse of discretion standard, which this court applies in reviewing the denial of a motion to reopen, is deferential.
And it's
but
the abuse of discretion by the board.
Correct.
The BIA itself.
But
Not
one.
the IJ or anything.
Correct, by the board, but as I said, there's two ways, at least two ways, in which the agency abuses its discretion. One,
But you wanted to reopen a decision earlier that resulted in his removal,
correct, Your Honor.
but for changed circumstances?
No, I mean, we're seeking a reopening based on a marriage to a U.S. citizen.
Well, that's what I mean, but the marriage had occurred after.
It did occur after, but the
removal,
board's own case
and-
law, this case
and
matter.
He got married and there were other facets to it, but then that was the basis for the motion to reopen.
Correct, but the board's case law makes clear that if certain factors are met, including clear and convincing evidence indicating a strong likelihood that the marriage is bona fide, namely the matter of.
Clear and convincing is a pretty strong standard.
Well, I mean, it's strong, but it's not beyond a reasonable doubt.
It's more than a preponderance, though.
It's more than a preponderance, but.
Not a reasonable doubt. I'll
But
I'll
there's-
agree with you. We can agree on that.
But, I mean, the pertinent regulation discusses the type of evidence that can be presented to show that the marriage is bona fide. That includes, among other things, a joint lease agreement and affidavits by third parties, both of which were presented here, along with other evidence that the petitioner entered into the marriage in good faith. And this is the key point, that
But after you lost the motion to reopen, you moved again, then you moved to reconsider or something.
Yes,
There's
correct.
another motion.
Yes, we filed a motion to reconsider, and we also filed a second motion to reopen after his wife had become pregnant, asking if they sua sponte reopen the case at that
Was
point.
with more evidence, or bring them current with the facts, I guess.
I'm sorry, I didn't hear every,
That's all right. So I said, you were adding additional evidence.
yes, because, I mean,
for the
obviously the fact
proposition.
that she became
What happened
pregnant.
to that second motion to reopen?
I'm sorry, again, I
What
didn't.
happened to the second
Oh,
motion?
they denied the second motion to reopen, saying that it was,
Okay, and that brings you here.
yes, that brings us here.
And for what do you want us to do?
I want you, we're respectfully requesting that you reverse the decisions by the BIA and vacate.
Which decision?
All,
The final one?
Or the earlier one?
well, I guess I would qualify this by saying I understand that there's an issue about the court reviewing the denial of a motion to reopen on sua sponte grounds. So, but aside from that, I think that you should reverse the initial decision dismissing his appeal. You should reverse the denial of the timely motion to reopen, and given that that decision's obviously, in our view, is incorrect, you should also reverse and vacate the denial of the motion to reconsider. But it would suffice for you to reverse the decision dismissing his appeal and the denial of the.
And to do what? Send it back for more hearings, or?
Well,
You want us to
well, I
decide it?
think-
What do you want us to do?
I think this court could conclude that under any standard.
I could conclude. What do you want us to do?
I would suggest that you send it back to the Board of Immigration Appeals so that it can.
For whatever proceedings they think appropriate.
Correct, so that they can, with respect to the motion, that they can properly grapple with the evidence and apply the correct standard in the first instance. And also because the initial decision dismissing his appeal is based on, is also clearly incorrect. They upheld an adverse credibility finding that is ultimately based on pure speculation.
Well, but you said they applied the wrong standard. That's an error of law?
Yes, that's an error of law, correct.
And describe that error of law that you claim to rely on.
Well, I think as they didn't apply the correct standard in terms of looking at what constitutes clear and convincing evidence indicating a strong likelihood that the marriage is bona fide. As we point out, they also,
What specific is the error of law? You kept saying they didn't apply the right standard. What's the standard and what's the incorrect one they applied?
as we argue, they should have looked to whether the evidence sufficed to indicate that it was highly probable that the petitioner had entered into a bona fide marriage. Instead,
Why don't you quote the language? The fact is that the standard that the agency has applied for reopening this type of a petition is a strong likelihood of the bona fides of the marriage. The agency, the BIA in this case, in fact, said clear and convincing evidence that the marriage was in fact bona fide.
Correct.
That's the answer you probably should have given to Judge King if you were.
Thank you, Your Honor. I think I appreciate that. I agree with that. They didn't.
Well, I thought you might.
Thank you, Your Honor.
I wasn't trying to trick you or anything. I'm just trying to get it straight, in my mind.
Okay.
On the asylum issue, it appears that the IJ gave, well, this court will, of course, give deference, but he gave cogent reasons as to, I mean, the marriage license, I mean, not the marriage, the medical note is just a handwritten note. It says, I mean, he goes on and explains, I guess, the IJ goes on and explains that it details no treatment, it details no injury. He says he's a part of this blue party, but there's no letterhead, there's no card. Why is that not sufficient? The country report says that, there were no arrests as a result of the protest. Why is that not enough in terms of reasons that is stated by the IJ?
Well, I think this court needs to look to what the board said in upholding so they didn't, what the board really did is focused on the implausibility findings when it upheld the IJ's adverse credibility determination. Now, we think the IJ erred in other respects as well, but really what the board focused on was these sort of supposed implausibilities of his account.
Well, that's trying to give substance to a factual finding that the fact finder found, which was incredulous testimony. In other words, when the fact finder finds things incredible and explains why, the board can add to that to basically say it's implausible in order to verify or justify it. But it seems to me it's very hard to reverse a fact finder that says somebody's testifying incredibly.
It is very hard, but not impossible.
Not impossible, but I don't understand how you want us to stand in the shoes of the board and say the board didn't act appropriately in recognizing it when the IJ explained why he was incredible, and the board supported that and said, supported that incredibility objectively, saying it's implausible. That's just an additional support for the incredibility of it.
Well, I think that the court should carefully examine the reasons that the board gave for upholding the implausibility findings, which are all ultimately based on speculation.
But it's ultimately an incredibility, a credibility question.
Yes, but, to say something's implausible,
Not
if it,
implausible, uncredible. There's a difference. The
Okay,
implausible supports, fortifies a credibility finding, but we're reviewing a credibility finding here, just as the board did.
Yes, Your Honor, I appreciate that, but when the board explained why they were upholding the negative credibility determination, what it focused on was the aspects of the petitioner's account that were supposedly implausible. So I think it is appropriate for this court to review that portion of the board's decision.
But we're only supposed to reverse if we are compelled to find otherwise, right?
Well, I think you would be compelled in
Isn't
this
this
case.
statutory standard compelled? We have to be compelled to find otherwise.
I don't dispute that, Your Honor. I agree with that. However, I
Okay,
think
and then on top of that, we have the credibility standard of a substantial deference.
yes, I'm not disputing any of that, but I do take issue with the reasons that the board gave for upholding the adverse credibility finding based on his account supposedly being implausible. First of all, the board is saying that it's implausible that he was arrested as a 16-year-old high school student in 11th grade in 2005, and then some 4 years later in 2010 is able to get a job with a government agency in Ethiopia. I mean, that's completely speculative, and it ultimately.
Well, they also say because he makes his allegation that he's a part of the Blue Party and working for the government at the same time.
So he joined the Blue Party in February of 2013, after he joined the government agency and started working there in 2010. So his ability to begin work at that agency has nothing to do with his being a member of the Blue Party. That's something that happened later. So that, that doesn't support, respectfully, that doesn't support an adverse credibility finding. Now, it doesn't seem that the agency was aware initially that he was part of the Blue Party, and perhaps there's some indication in the record that they learned about that after his arrest, but it's not implausible in the least that he would be able to first obtain a job in 2010 with with that government agency. And furthermore, the IJ just made a clear misstatement of fact when he stated in his decision that Hussein made multiple trips to China as a government employee before ultimately leaving the country for good. He only made one trip to China. That's just a clear misstatement of fact, and that's the sort of thing that this court should reverse because it's just not an accurate description. And it's also not in the least implausible that he was able to ultimately depart from Ethiopia via a bribe. That many asylum seekers leave their country through a bribe. That's not remotely implausible. Finally, the country report that the IJ cited in claiming that it's implausible that he was arrested after a protest that the government allowed to take place also documents that there was persecution of Blue Party members, so including arrests. So the notion that it's inherently implausible that he was arrested just because the government allowed one Blue Party protest to take place is not supported by the record. It's not inherently implausible for him to be arrested in a country where the government was systematically persecuting members of the Blue Party.
I thought that that the Blue Party, that the government report, the country report said that no one was really arrested after the protest. They allowed the protest, and that maybe there's no evidence of any arrests after.
Your Honor, so I see my time is can I answer this question before?
Yes.
I don't think, I'll review the country report before my rebuttal, but I don't think that's an accurate description of the country report. I think it does say that the government allowed the protest to take place, but I don't think that there's any indication that there were no arrests following the protest. But I'll review the country report before my rebuttal.
All right, thank you. We'll hear from the government.
Good morning, Your Honors. May it please the Court. Rachel Berman-Vaporis, the United States Attorney General. The Court should deny the petitions for review. Although the petitioner managed to become engaged and married within the 90-day period required to file a timely motion to reopen, the Board reasonably considered meaningful the lack of evidence of a joint life between the petitioner and his spouse following their marriage
A
ceremony.
short life? What,
A shared life, Your Honor,
shared life?
that they were sharing their
A
lives
shared
together.
life. Okay.
Instead of, for example,
You would agree that the board did not, they mention that there's a lease, but they don't consider the lease agreement, they don't consider this Geico car insurance, they don't consider the plane tickets of her moving to Alexandria from Ohio. They just say there's no shared life.
I disagree with that characterization, Your Honor.
That's what they said. I mean, you can't disagree. Well.
I apologize. Perhaps I
you disagree with
misunderstood
the
your question,
conclusion,
Your
but
Honor.
what Judge Benjamin says is correct, isn't it?
I apologize, Your Honor. I think I misunderstood your question. Would you please repeat it?
So my question is, do you agree that the board did not consider the lease agreement, the Geico policy, the plane tickets of her moving from Ohio and relocating to Alexandria in their decision? They just say there's no shared life.
No, Your Honor.
Okay.
The board specifically mentioned the Joyce lease agreement in its decision denying the petitioner's motion to reopen.
You know, I'm troubled even more fundamentally. The board cited the wrong standard. The board said the clear and convincing evidence with respect to the bona fides of the marriage, whereas the case they cited said on the reopening, you only have to satisfy a strong likelihood of the bona fides of the marriage and leave the actual finding of the bona fides of the marriage up to the hearing. You don't have to prove the ultimate fact at the reopening stage. And that looks to me like a clear misstatement of the standard.
It is true, Your Honor, that the petitioner did not need to conclusively show.
Not
that his-
conclusively.
Not show by
strong
clear.
likelihood, clear and convincing evidence of a strong likelihood of with respect to the bona fides of the marriage.
Yes, Your Honor.
And that standard seems to be more relaxed than actually focusing on the bona fides of the marriage.
You don't question the bona fides of the marriage, do you?
Yes, Your Honor.
You do?
Yes, Your Honor.
Well, there's a marriage license in the record.
Yes, Your Honor.
It's certified, and there's also a Islamic confirmation. I mean, there are two of them there, and they having a baby.
Your Honor, there's no dispute that a marriage ceremony took place and that the petitioner and his spouse are legally married. Or perhaps under the,
So you agree that they're legally married?
yes, Your Honor. The
Okay.
dispute is whether,
But is the government's position that it's a sham legal marriage?
the government's position is that the petitioner has not met his burden to show that it's not a sham marriage.
It's not what?
What's a sham marriage? If you say they were legally married, it was witnessed by family, people came from Africa to attend, from the Midwest, tickets everywhere. They did it in a mosque in Ohio before officials, witnessed by everybody, and then they had a big celebration afterwards. Is that a sham?
Your Honor, a sham marriage is one that is entered into for the primary purpose of circumventing United States immigration laws. So,
Well, what's a bona fide marriage? If, at this point, he's about to be deported, and he enters into a bona fide marriage, what would a bona fide marriage be? If he's a bona fide marriage, he could be adjusted, couldn't he?
yes, Your Honor.
All right, so he enters into this marriage, and you say it's legal but not bona fide.
It's legal, but he
And
did not.
because he entered into it in order to not be deported. But it seems to me, if it's bona fide, it's real, he loves her, they got together, they live together, they have a baby together, they have insurance together, the lease together, they share they have an endowment specified, they have family members all over celebrating it. What more do you want for a bona fide, or at least a strong likelihood of a bona fide marriage?
If I may, Your Honor.
Yes,
Some
of
of the
course.
evidence you mentioned came with the petitioner's second motion to reopen. For example, the evidence about the petitioner's spouse's pregnancy. And that is
No,
not
I didn't
properly.
say, I didn't use pregnancy. I said everybody attended the marriage, the people traveled far and wide. They went to
Yes,
a holy place where it was conducted. It wasn't conducted downtown in the clerk's office. They witnessed it. They had a celebration afterwards, and many people attending and witnessing it. They had a contract of marriage. They had the traditional practices in the culture of families agreeing to the marriage. I don't know what you want more. I mean, just because the marriage was entered into to prevent their leaving, if it's bona fide, it's okay.
Well, but the petitioner has to present evidence of that, Your Honor, sufficient
Of
evidence
what?
of that.
Of what more? What more could have been shown to satisfy the government?
A joint account.
what?
A joint bank account, Your Honor, showing the commingling
I
of
thought there was a
finances?
joint bank account.
Not with the first-
There was a lease in both their names, but what Judge
There's-
Niemeyer recited. to
My
you-
wife has an account and I have an account, and they don't have, and they're separate accounts.
Yes, Your Honor, so a joint
And so I'm
account.
not a bona fide marriage. Well, maybe I'm not. It's just been 60-some years.
What about all those grandchildren?
If I may, to answer these questions, I think it's important to put in context where this bona fide requirement comes from. From regulation, there's a healthy skepticism of marriages
There's no
entered
doubt.
into.
We've
during-
had a lot of sham marriages, and one of the typical ones is where they go down, get married in the clerk's office, and then they each go back to their own apartments. We've had that. They didn't even live together. It's a sham marriage. They did it to avoid deportation. But the question here is, what if they wanted to avoid deportation with a legitimate bona fide marriage? And I must say, we don't have to rule. The BIA, I think, erred in its standard. We don't have to conclude it's bona fide. We only have to conclude, was there evidence of a strong likelihood of that being bona fide? Because the ultimate question of whether it's bona fide would be determined on the rehearing. Right?
Yes, Your Honor, but if I may,
And I would suggest to you, you represent the Attorney General of the United States,
yes, Your Honor.
and you're standing here in the Fourth Circuit Court of Appeals. You've got a duty of candor to this court. And I don't know how you can say with a straight face, this is that the Attorney General considers this and not to be a bona fide marriage.
Forgive me, Your Honor. The dispute is whether the petitioner's marriage is bona fide, but the Attorney General is not saying that the petitioner does not have a bona fide marriage. We are saying he did not meet his burden to show, by clear and convincing evidence, a substantial
But you have to
likelihood
start-
that his
You
marriage
have
is
to
bona
start
fide.
with the proposition that the marriage is bona fide.
But for the motion to reopen, as Judge Niemeyer said, is a strong likelihood. The motion, you're saying clear and convincing, that's what would be decided at the rehearing. The strong likelihood is as to so here we are looking at the motion to reopen. And the board just says, there's no evidence. And and then we have before us all of these things that he's presented, and you mentioned the regulation. The regulation specifically says, lease showing joint tenancy of a common residence, documentation showing commingling of financial records, affidavits of third parties having knowledge of the bona fide marital relationship. I mean, I think he submitted at least 4 or 5 affidavits regarding the relationship. And then there's these pictures in Ethiopia, and the families go to Ethiopia ahead of time. And then you have the flight where she moves from Ohio to Virginia. And so the issue seems to be that the board just says that there's no evidence and of any shared life, and not considering all of these different documents that were submitted.
The board did not engage in a lengthy analysis of each piece of evidence, Your Honor.
I
but
don't think
it
they did any analysis. They just said, no, there's no evidence. There's a lease, but there's no evidence of a shared life. And I understand you're saying that it's potentially a sham marriage, but that would, had they reopened it, that would be determined at the hearing.
Well, but by regulation, Your Honor, the petitioner is ineligible for adjustment of status based on a marriage that he entered into during removal proceedings. Ineligible, full stop, unless he meets an exemption. And the exemption is the bona fide marriage exemption, which
Well,
is what he's trying to show.
that's where we're at. There's no question that if it's bona fide marriage, it's okay, right? If it's bona fide.
If he presents
Yeah.
clear and
And
convincing evidence of a substantial
If he
likelihood.
demonstrates, now, at this stage, when we reopen, I'll pass that we only have to show a strong likelihood of a bona fide marriage. But let's assume at this point, we're setting that aside, and we'll just look at what the evidence is. A sham marriage would be one where there was never an intent to be married. The only reason of going through the process is to avoid deportation. Here, there is a lot of evidence of intent to be married, to be joined or into a family. Now, you say the evidence they should have shown is a joint account. Is there anything else they should have shown?
That's an example of the type
Well,
of
give me
evidence,
another
Your Honor.
example.
Joint ownership of property,
Well, they did. They showed a lease where they both were on the lease.
that's a rental agreement, Your Honor.
That's an interest in property. You know,
That- that
that's
is-
routine property law.
That is an interest in property, Your Honor. But
So
as
they
it was
can't,
stated,
they can't rent and be married?
of course they can, Your Honor. But
And
what
doesn't
the
it,
board was
if they
looking
put
for-
both names on the lease, and they put both names on the insurance and the car?
Which is temporary, Your Honor. And rental
Well, what's
agreements
the
are
evidence of
temporary.
that? What's the evidence of that?
The car insurance had an expiration date. I believe it started in January
Well,
and then
that's for
expired a few months
everybody.
later. Yes, Your Honor. So, and
But
the
you
board
can't rely
acknowledged.
on, you can't rely on and say it's a sham simply because an insurance policy has a termination date.
Well, that is not why I'm trying to say, Your Honor, and I
mean, because
apologize
if we're
if I
going to look
said that.
forward, then we have to also look forward in the fact that they consummated the marriage and had a baby.
Well, Your Honor, that is evidence that was submitted with the motion that was, the
I know,
second
it's,
motion to
we're not
reopen. It's not
considering
before the
that
court.
on the motion to reopen. But my whole point is, you're looking at things like they sign a lease and you say, oh, the lease has a term and therefore it could be a sham. Or insurance, it has a term and therefore it could be a sham. Well, the whole thing could be a sham. They could be a huge conspiracy. People came from Ethiopia by airplane. People came from the Midwest. They came from all over the country. They came to this ceremony, attended it, signed a contract, had a party afterwards. Big conspiracy. There must have been about 50 people had to agree, right? That it was a sham?
I thought I read there was up in the hundreds
Yeah, there maybe was.
at Columbus, Ohio.
Your Honor, it's,
And those licenses. You question the validity of the marriage licenses?
I do not question that the petitioner is legally married,
There
and
were
he
two
may
of them.
also be married
There were two of
according
them.
to the customs of his religion. That may be true, Your Honor. But it's not just whether a marriage exists. It's whether he entered into the marriage with the primary purpose of circumventing United States immigration laws or not. And the board looked at his evidence
Well, let me
and
ask you
said-
this question hypothetically.
Yes, Your Honor.
If every indication that you can think of showed it was a bona fide, but they entered into the bona fide marriage in order, at this time, in order to avoid deportation. But they agreed, they loved each other, they're going to stay together for life, they merged all their property, they consummated the marriage, everything that you can think of, but the timing was the same. Would it be okay?
If they presented sufficient evidence, Your Honor, then yes.
Okay, well, theoretically, it'd be okay. So now we're down to an evidentiary question, whether they presented, not whether they entered into it to avoid deportation. That may be a legitimate conclusion. The question is whether their marriage is bona fide or a sham. And if it's bona fide, all they have to show to reopen is a likelihood, strong likelihood that it can be shown. And then at the hearing, you'll hear the evidence of what they have. And you'll see these pictures, and at the rehearing, you'll hear where their bank accounts, where their money is, and endowments and everything else. You can hear anything they want to hear. But at this point, the question is there evidence of a strong likelihood? And the BIA didn't even apply that standard.
I would like to address that, Your Honor. The standard, as you mentioned at the beginning of my argument, is clear and convincing evidence of a substantial likelihood
Right.
that the marriage
That's
is
the
bona fide.
standard, but they cited in their brief a strong likelihood, not a strong likelihood, clear and convincing evidence of a bona fide marriage.
The board did.
That's what they said.
The board did say that,
Yeah.
Your Honor.
Well, that's the wrong
But
standard.
it also cited to the case
Right.
that gives us this standard, matter of
But they construed it wrong.
So they knew better, or should have known better, because they had it before them, but they applied the wrong standard.
Or since the petitioner had to meet the clear and convincing evidence to show a substantial likelihood, they merely found that the petitioner did not meet that first part, did not show clear and convincing evidence of a substantial likelihood that his marriage was
They didn't make
bona
that
fide.
finding. They made a finding that they didn't show a substantial likelihood with respect to the marriage itself, bona fides of the marriage.
Yes, Your Honor, but given that the board cited to the case that stands for this proposition.
So they say one standard and cite a case with another standard, and you think they've done the right thing?
I think the board did not recite the entire standard as provided in matter Velarde Pacheco.
Well, maybe they
but by-
applied the standard they said they were applying. Would that have been error if they applied the standard they said they were applying?
If the board applied the incorrect legal standard,
No,
then
and-
that would be error, Your Honor.
If the board applied the standard that it said it was applying without the case, was that a problem?
If the board had not cited to matter Velarde Pacheco, then that would have been a problem. But here with that citation, taken together with the clear and convincing standard being part of the definition.
We're supposed to read it as if they applied the one of the case they cited, not what they said they did.
Well, the case
We're supposed
citation,
to correct it for them in the context of all this evidence of the bona fide marriage.
well, of course, just looking just at the evidence submitted with
I
the
mean,
first
this is
motion
not
to reopen.
rocket science. I mean, it's beyond the reasonable doubt. There's a marriage, and it's bona fide. It's stamped, it's stamped by the clerk of the court and the ministers and the officials of the Islamic mosque out there in Columbus,
And the families are coming together, and the families were specifically agreed to the marriage ahead of time. Parents, this is not the petitioners here. Would they have done so if it was a sham?
Well, if the petitioner obtains a green card, he would then be able to petition for
No,
his
no,
other
I'm not
relatives,
talking
Your
about a
Honor.
green card. If the parents agreed to the marriage, and then it was held, does that indicate that there was a sham?
That on its own, Your Honor, no. I would not say that that is evidence either way.
You
You
don't
need to
think
look
so?
at all of the evidence taken together, because from regulation, he's ineligible for adjustment of status
You just
unless
said
he meets
he's
an exemption.
eligible if he shows a bona fide.
If he meets an exemption, Your
Yeah,
Honor.
okay, that's
Yes.
what we're determining. And he sought to reopen on the basis of a bona fide marriage, his claim. And
Yes.
and you guys looked at the evidence and said, no, that's not enough.
Yes, Your Honor.
Okay.
And doesn't the BIA have to give a reason, analysis as to this decision? So just saying there's no evidence of a shared, a life would not be, they give no reason as to why there's no shared life. They just said there's no evidence of a shared life. Wouldn't that be abuse of discretion?
No, Your Honor, because the board discussed the evidence, the main evidence submitted with the motion, and said this was not enough to show by clear and convincing evidence, a substantial likelihood, of course, the board did not use that language, that his marriage was bona fide. And I just think the context of this is important. By regulation, the
Well, the
petitioner has the
context,
burden.
you've got a very strong matter on the context. I mean, because the timing, of course, is critical, and they obviously wanted to avoid deportation, but the question, I don't think that, you agreed that that doesn't resolve the question, the timing. The question is whether, in fact, in the end, the marriage was bona fide. If it's a bona fide marriage, then you can consider an adjustment. And so the question at this stage, they moved to reopen. The question at this stage is, have they satisfied the gate, opening gate, to get in, to have the agency consider whether the marriage was bona fide? I mean, the issues before us now is not whether the marriage was bona fide. The
Yes,
issue
sir.
is whether the strong likelihood, that they've shown a strong likelihood that it was, in order to entitle the agency to rehear it. And it seems to me that's a lesser standard than the actual conclusion that it's a bona fide marriage. Now, your argument's going to be, I suppose, we don't have evidence of the bank account, we have the timing, we have a very short period of time during which they got to know each other. But of course, that presumes, even making that observation, that presumes that we have long engagement periods in Western cultures. We get down on our knees and ask the parent, and wait a year and all this other stuff. That isn't necessarily, and they explained that that was not consistent with the culture. That wasn't, and you didn't say that was a sham. Now, you could say that's a sham too, maybe, I suppose, that they invoked the culture for their marriage. But I must say, under that culture as described in the documents, that looks like beyond a strong likelihood. That actually looks like they had a marriage, a bona fide marriage.
I see my time has expired, but if I may
You
answer
can-
your
You
question.
can answer whatever you wish, sure.
Thank you, sir. I think it's important to note the evidence we have that the petitioner's length of courtship, engagement in marriage is inconsistent with this culture really only comes from his affidavit. And as the board noted in denying his second motion to reopen, he never addressed, let alone overcame the adverse credibility finding.
That's a
in the
good
prior-
point. I mean,
in the prior
and there may
proceedings.
be some of that in this whole case. In other words, the incredibility finding with respect to his original petition for asylum bleeds over, and they don't believe him. But I must say, he had a long affidavit, but there were about 5 or 6 others in there, and there were pictures, and there was no reason to disbelieve all those. And there was a license, there was a contract, marriage contract, and all these other things signed. It took place apparently undisputedly in a mosque, a religious forum, not a civil forum. A lot of indicators, and the question is that a strong likelihood? It seems to me at the least, it would have been good for the BIA to recognize they didn't have to go to the ultimate question, but had to only determine whether the gate should be opened.
Whether there is clear and convincing
Yeah,
evidence
yeah.
of a substantial likelihood.
Yeah.
I understand that, Your Honor. And I just want to briefly mention that the petitioner
I'm gonna
has,
ask you something more.
the petitioner has multiple avenues
I
to
want to
adjust
ask you
his.
something.
Oh, I apologize, Your Honor.
If we send this back, what's the BIA do with it?
How does it resolve it? Does it send it to the IJ for more hearings, or what, if you know?
It
Or
depends.
if you don't know, what would you recommend they do?
It would depend on the posture, Your Honor.
Pardon?
It would depend on the posture, the
If we
wording of his
send it
court
back
statement.
and vacate what you're ruling,
If the,
and tell you to do whatever needs to be done, what will you do?
if this court,
And I'm talking about you, the BIA, the Attorney General, how you all handle this. I want to know
If-
how you will handle it. And you're the lawyer, how would you recommend they handle it?
the court sends this case back to the board stating, we don't believe you applied the correct legal standard, you cited the
No, if
case.
we just send it back to you and tell you to keep going, and we vacate the ruling.
We go
Listen to
beyond
me.
it, yeah.
We vacate the ruling and send it back for further proceedings, appropriate proceedings. What are you going to recommend they do?
I guess I don't understand, Your Honor, if we're sending it back to the board on a legal error, or if this court is making the legal
We
determination.
conclude that there's a strong likelihood evidence shown.
Then proceedings would be.
And then, so we tell them to reopen. Then the question, where does it go?
The immigration judge, Your Honor.
The
And,
BIA sends it back down?
Yes, Your Honor, because the board has very limited fact-finding ability. And
And then-
so, since
And
there
then
was,
the IJ would do the same thing that they did on the asylum claim. Weigh the evidence, the legitimacy of it, credibility of the affidavits. That would be the place where you would, your argument regarding credibility, right?
that is where the Department of Homeland Security would investigate the petitioner's claims through an immigration court hearing. The petitioner would present evidence supporting his marriage being bona fide, and the immigration judge would come to that conclusion, as well as addressing the other eligibility requirements for adjustment of status, including whether he merited as a matter of discretion. And in considering the evidence, Your Honor, that is where the immigration judge may take into consideration
And
the
at
adverse
that point,
credibility
you can
finding.
make the point that if the timing's questionable, you can talk about the credibility finding in the other proceeding. You can talk about whether that culture demands that, whether they combine bank accounts and that type of thing, whatever your questions you had. But that would be the place to do that, right?
Yes, before the immigration judge, though, of course, if the court denied the petitions for review, the petitioner could also seek to apply for adjustment of status through United States Citizenship and Immigration Services, and then they would do that investigation where they would gather the evidence, give the petitioner the opportunity to provide additional evidence, and then adjudicate his application for adjustment.
Where did this come from to the board? Did it come from the IJ on this issue, the marriage issue?
No, Your Honor.
It came from the adjustment board?
No, Your Honor. It was before the board in the first instance, in a motion to reopen. Because since the petitioner.
That's the reason, they're up here on the decision of the board.
Yes, Your Honor. So only the board has looked at the petitioner's motion to reopen based on his marriage and the evidence he submitted.
So the
with it.
board has an option to where to send it, if we were to reverse the board, they can send it to one of two places, you say?
The board would send it back to the immigration court, Your Honor, if they felt that more fact-finding is needed, which I presume it would do. I merely mentioned the Department of Homeland Security because that's just an alternative to adjusting status after filing a different form or two. But if this court sends the case back to the board would very, very likely determine that more fact-finding is necessary and then send it down to the immigration judge for further proceedings, which would involve consideration of all the evidence submitted so far, as well as any new evidence submitted.
That's helpful, thank you, thank you. All right, you want to? Oh, yeah, yeah, okay, thank you. We've let you go through, that's helpful, thank you.
Thank you.
Mr. Diskin?
Yes, the answer is yes.
Yes, I just wanted to make a few more points in rebuttal. With respect to the demonstration, I did check the country report, and it's silent as to whether the government arrested anyone following that demonstration. This is on Joint Appendix 624 and 625, but the same country report directly states, and I quote, "The government arrested persons in relationship to opposition demonstrations." So you have this evidence in the record that they've been arresting people following demonstrations, and I think it's just, not remotely implausible that they arrested the petitioner after this specific demonstration, even though the government did conceitedly allow the demonstration to take place. There's a variety of reasons why they might allow one or two demonstrations to take place, but it doesn't mean that they wouldn't necessarily observe who attended that demonstration and arrest some of the participants, especially when you have this evidence in the record that they not only arrested persons in connection to opposition demonstrations, but were specifically targeting members.
How's that relevant to what we have, the question we have before us here?
Well, that's relevant to the initial decision dismissing his appeal, because one of the implausibility grounds is that it's supposedly incredible that Hussein attended a demonstration that was allowed by the government and was arrested.
That's on your asylum case.
That's in his asylum case, correct.
But you understand that the immigration judge they have to determine credibility, and he does, and then they have to give a reason, and that's what the immigration judge does. He goes, and the BIA considered the immigration and goes back and recites what the immigration judge did in considering, and that was one of the things, is that he's working for the government, that he is working for the government, that he's not arrested based on his country report, there's no arrest, that he's basically kind of a bystander. I mean, they adopt the findings of the immigration judge.
Your Honor, I'm not sure that the board actually expressly adopted all of the findings. They mainly focused on the implausibility findings of the immigration judge.
I don't know, they said, they referring to the IJ, and they said they found it not credible because the testimony was, quote, vague, lacked detail, and was implausible. He further found that corroboration provided was insufficient. And then they conclude on the next page that we discern no clear error in the immigration judge's adverse credibility finding. I mean, the court BIA did explain other stuff, but it seems to me.
So, Your Honor, the way I read that is on Joint Appendix 428, it's kind of.
He's reciting the IJ.
It's reciting the procedural history, and then this paragraph that says, "We discern no clear error in
Right.
the immigration judge's adverse credibility finding," that's the board's analysis.
That's what I said.
Yeah, yes.
But that's what we're reviewing, right?
Yes, and that's the part
But
that.
you tried to narrow it all to just plausibility, and I'm suggesting that it's more than plausibility. It's plausibility, vagueness, insufficiency of corroboration, and lack of detail.
Your Honor, respectfully, I disagree because as I read the decision, they don't specifically uphold the vagueness finding. They focus on the plausibility, and then they go on to say that we agree that the corroborating evidence does not rehabilitate his incredible testimony. But regardless, I think that the plausibility findings that the board addressed are based on speculation and in themselves warrant reversal because they're just completely based on speculation, all of them. As I said, we talked about the protest. It's also not remotely implausible that he was able to get a job with the government when he was arrested as a teenager several years prior to that. It's not remotely implausible that he went to China as a government official and the immigration judge mistakenly stated that he went multiple times as a government official when he went one time. Aside from that, it's not implausible that he was able to depart from the country for good after paying through means of a bribe. None of them are implausible. So I think when you look at that, you should, and that's what the board focused on, it's just not supported by the record. It's quintessential speculation of the sort that this court should not find sufficient. So I see that my time is about to expire, so I'd respectfully ask that this court vacate the decision and reverse the decisions by the board below.
Thank you. All right, we'll come down to Greek Council and take a short recess.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated, please. All right, the next case we'll hear this morning is United States versus Thompson. And Mr. Guelph will hear from you. Macbeth.
All right, thank you and good morning, Your Honors. My name is Cullen Macbeth, and I represent the appellant, Kyrie Thompson. Your Honors, Mr. Thompson challenges the government's decision to order Google, without a warrant and in the absence of probable cause, to copy and preserve the contents of 2 of his email accounts, thereby depriving him of the right.
Can I just jump in there? You said copy and observe. I understood they did copy it after the subpoena and put it in a file, but that before the subpoena, it's on their server, and they just barred him from deleting it.
So,
It's already on their server now, all emails on their server.
yes, so before Google received any process from the government, files were on their server. What happened when the preservation letter was sent is Google went into wherever they store those files, made a copy, and put that aside.
I don't think they did that until they got the subpoena. I think they just put an order on barring deletion, because it's already on their server.
It is, and
Is there evidence in the file that they copied it separately at that point and set it aside?
well, that's certainly what we alleged in our district court filings. The
Well,
government.
that's why I'm questioning you, because I didn't see any evidence in the record of that. It's inconsistent with my understanding. And so I just wanted to have record support for the fact that on the preservation notice, they made a copy, as opposed to just barring the user's access to it.
They did not
They
bar.
didn't bar access, they barring his deletion.
Correct. So we're a little bit in the dark here because, there was no record developed below about
But
exactly.
you seem to make a big deal about it. That's the only reason I jumped in, because the preservation order basically means don't let the evidence be destroyed.
Yes, but the way.
And the actual copying, they sent a letter saying, we have put it into a file. They gave the number and certified it in their letter, and that's how the government gets it.
Yes, but the way the government prevents it from being destroyed is by making a copy. So
Well, that's on the subpoena, because that's in the record. It shows it. Google said they did it.
Right.
But I'm talking about the preservation notice, saying just don't let it be destroyed.
Well, so
It's on their server already, and all they need to do is leave it on their servers and not permit access to destroy it.
Preservation means preservation.
Right, but so we cite in this appeal Professor Kerr's article, which is sort of an overview of how this process works based on his discussions with companies like Google and Facebook and companies like that. And what the people at those companies tell him is the way companies respond to these preservation letters is going to the original underlying sort of master copies of the files, making a new fresh copy, and putting that aside. And that is what the user cannot access or delete. The user can still go into his underlying files, delete those, but that doesn't matter.
Well, I didn't see that in the record.
Well, so again, we're sort of in the dark here because we asked the government for a copy of the preservation letter. The government refused to produce it. The government also, when we stated this set of facts in district court, never disputed it. The government is the one, of course, who dealt with Google in this case.
And it's sort of counterindicated by the letter from Google that is in the file. But you can go ahead. The only point I raised that is you make a big deal under the Fourth Amendment and saying copying is a search or a seizure, when, of course, the data is in their possession already. It's not, they didn't take it from anybody. What they did is they prohibited it from being destroyed in accordance with statute and spoliation aspects. That happens in the civil courts all the time, as you know, that you send preservation letters, tell people not to destroy documentation pending the filing of a lawsuit or the discovery in a lawsuit.
Sure, no, and to be clear, we're certainly not contending that anything Google did prevented Mr. Thompson from accessing his account. That's not our claim. It's just that because the copy had been made, at that point, he can't.
You're not contending it was anything improper of them asking for preservation?
Well, we do. We think that's a seizure because
Well, improper,
well, it's a
that there was a
seizure.
seizure without a warrant?
Correct, a seizure without
All
a
right,
warrant.
I say it's violation of the Fourth Amendment. But you waived that by pleading guilty.
Well, so that's where I was actually going to start, Your Honor. So I think,
Okay,
Well, let me just ask
Went
you
in and
something.
Your client went in and pleaded guilty, straight up.
he did plead guilty, Your Honor, but we think this case is controlled by
Well,
United States.
there's a provision in Rule 11 where you can get away with that. You can plead guilty and preserve the right to appeal a suppression ruling, but you didn't do that.
Correct. So we're not claiming, to be clear, that this was a Rule 11 conditional plea. What we're claiming is it was an unconditional plea that was invalid because the district court misadvised.
So you want the plea set aside?
Well, so
Well, that doesn't give you a right to challenge the ruling.
Well, so we-
That wouldn't give you a chance, that still wouldn't give you a right to challenge the suppression ruling.
So 2 points, Your Honor. First of all, we think if you take the principles from United States v. Manigan and apply them to this case, they mean that Mr. Thompson can appeal that. Because what Manigan said is if a district court affirmatively misadvises a defendant about the scope of his appellate rights, then the waiver is
But
not
the appellate
knowing-
rights, if a court misadvises a defendant of the appellate rights are not part of the guilty plea. They're part of what happens after the guilty plea is entered. In other words, you can appeal, if the court said, in this case, you've pled guilty, and we understand that, and you can appeal the suppression order, and we said, no, he couldn't, they didn't satisfy the criteria, the district court couldn't change our scope of review on appeal, but that doesn't go to whether the guilty plea is valid or not, that's just whether you can appeal it.
So Manigan is based on the validity, the knowing and voluntary.
Yeah, but
nature of the-
Manigan is a conditional plea, where we have an unconditional here, right?
No, Your Honor. Manigan was a plea in which the defendant expressly waived all right to challenge both the conviction and the sentence on appeal. He waived all his appellate rights.
But this is
But that
not a
was-
conditional plea.
No, but neither was
And
Manigan.
which means he cannot appeal the suppression ruling.
So
That's just the way it is. I was a prosecutor and a defense lawyer for years before they had this Rule 11. And if you pled guilty, if you had a bad suppression ruling and you pled guilty, you waived it. And then there was nothing in between. If you wanted to preserve it, you had to go to trial. And they changed it in Rule 11 to set it up so the defendant could do that if the prosecutor agreed. And they could have a conditional plea. You could preserve the Fourth Amendment right and do it. But you got to jump through the hoops. But that's the limit of it. Rule 11, what Rule 11 says. And if you don't have a conditional plea now, it's gone.
So that is certainly.
So if you want this set aside, if we were to set it aside, that doesn't mean anything about a conditional plea.
Yes, so 2 points, Your Honor. One is, I absolutely agree that what you just described is the general default rule. And we've never claimed this is a conditional plea, but the plea in Manigan was also not a conditional plea.
But there was a plea agreement in Manigan. There's no plea agreement here.
There's no plea agreement here.
Correct.
He
But
pledged straight up. That's what we used to call it. I don't know what you all call them now. But if you plead straight up, that's it. It's over.
so,
It's all gone.
understood, Your Honor. So I think
You get a sentence and go.
the principle for Manigan that I'm trying to apply here is that when you give up certain rights to appeal by pleading guilty, if your knowledge of the scope of your appellate rights is erroneous because you've been misled by the district court, then you are not limited.
But
in
there
the way-
are no appellate rights. If you plead straight up, there's no appellate rights. You get a conditional plea, there are appellate rights. And you get the conditional plea by negotiating with the prosecuting attorney.
Yes.
By the United States, negotiate with the U.S. attorney, he can agree to a conditional plea. And you
Understood,
don't
Your Honor.
have that here.
Right.
And we can't give you one simply by vacating the conviction, the sentence, and sending it back. That wouldn't help you a bit.
So
That's not going to do what you want.
So there were no appellate rights in Manigan either, though, is the point I'm trying to make. And nevertheless, the court reached the issue. That said, if the court thinks that Manigan doesn't apply and that this case is more like Fitzgerald, which is the case the government cites, then Mr. Thompson should at least get the remedy from Fitzgerald. Which
But
is,
I think, and maybe maybe I'm misinterpreting, but I thought in Manigan that the issue there was that there was an agreement, and because the government did not object to the district court's, I guess, comment regarding the appeal, that was the issue in Manigan, because there was no objection there, and because there was a plea agreement, but we don't have a plea agreement here.
Correct. There's no plea agreement here. The government, of course, in this case, did not object either when the district court misadvised Mr. Thompson. So I think
We can't give you a plea agreement by vacating these convictions. We
So-
can't do that.
So if
You don't have a plea agreement.
then, and
He pled guilty straight up to 5 counts, I think it was,
2 counts, Your Honor.
2 counts,
Yes.
whatever it was. He pled guilty to the indictment.
So if
And he
that's.
didn't have an agreement.
Correct.
So he's under the old rules.
And if that's the case, then his guilty plea was not a knowing and voluntary and intelligent plea. And what this court said in
Well,
Fitzgerald is,
I'm just saying, if we vacate it and send it back, he doesn't get any relief
Well, he
with
does.
respect to this suppression issue. You want to argue the suppression.
so he
And the
wouldn't,
suppression is gone by the fact that he had he pled guilty. He doesn't have an agreement.
so Your Honor, if the court sends the case, vacates the plea and sends the case back, Mr. Thompson will actually get some relief, which is that at that point, he can decide anew whether to go to trial or plead guilty. And in this case, he has every incentive to go to trial because the first time he pled guilty, he got 0 benefit for doing so. The district court did not grant him acceptance of responsibility. He knows what sentence he would get based on what the district court did the first time. And so at this point, he really has no reason not to go to trial or at least try to negotiate a better plea with the government. So that there is meaningful relief for Mr. Thompson if the court vacates his plea agreement and sends it back. And that we think if the court is not going to reach the suppression issue, that it should at least do that, which is
No,
what
but
it
the
did.
suppression stuff you're arguing is irrelevant to all this.
And I'm saying, yes, Your Honor, I
That's
understand.
in my thinking.
And I understood,
it
Your Honor,
is.
and
I
I'm
mean,
saying,
But that's where you started out,
and I'm saying even
talking
if,
about being able to suppress the evidence. And that was given up.
understood, Your Honor, and I'm saying, assuming that's true, the plea was still not a knowing and voluntary plea, which means it has to be vacated and sent back so that Mr. Thompson can decide anew whether to plead guilty, excuse me, or go to trial. So that's the remedy that the court gave in Fitzgerald. That's the remedy the court gave in United States versus Bundy, which is the case Fitzgerald relied on and cited. It said there are 3 options. Either the defendant entered a valid conditional plea, he entered a valid unconditional plea, or there was no valid plea. And if there's no valid plea, the plea has to be vacated. The court said use the word must. The plea must be vacated and sent back. So if the court believes that the suppression issue is
Well,
waived.
he clearly knew there was no plea agreement.
correct.
He didn't want a plea agreement.
Well, there were negotiations that didn't work out, but in any event,
He
there was
didn't
no
want
plea
a plea
agreement.
agreement. He pled guilty straight up.
Correct, correct, Your Honor. So
And the consequences are, you
consequences
get
are,
sentenced.
sure, sure.
Do I understand your argument to be that in the dialogue for the accepting the plea agreement, the court misinformed the defendant about his right to appeal?
Yes,
And that therefore would have changed his wish to plead guilty?
yes, that means that when he
You mean
enters
he was,
that,
in pleading guilty, he was relying on the fact that he could appeal the guilty plea?
yes, because the district court told him that. District court said you have an unlimited right to appeal any issue, any ruling, not just sentencing, any other underlying ruling the court made in this case. So, and this court was very clear in Manigan, and other courts have said as well, that when a district court affirmatively misadvises a defendant, the defendant is allowed and entitled to rely on what the court tells him because the
And
court
so
is.
did you file a motion to vacate the plea?
No, we didn't. We were asking the court to reach the Fourth Amendment issue, but
Were
if
you
the court-
there when this happened?
I was, but I wasn't at council table. Oh, sorry, for the change of plea, I don't think I was at the change of plea.
And none of the lawyers interrupted and told the judge, you may be wrong on this?
No, no one said anything.
What about their obligation? What about that?
Defense counsels?
Defense counsel, the prosecutor?
Right, I
The
don't know.
lawyers.
I wasn't
They were
at,
standing there.
right, I wasn't there. Again, the government didn't object. I don't know, I can't speak for, my colleagues who were taking the plea with the client, but in any event.
Did you know that he didn't have a right of appeal anything? You were
So I know.
you were in the courtroom, you said.
Not for the change of plea.
Somebody should have piped up and said, Judge, this is a straight-up plea.
So I was not in the courtroom for the change of plea,
The
Your Honor.
Rule 11 doesn't apply.
And again,
Black and
if
white.
the court says that, then that means still that Mr. Thompson's plea was not a knowing and voluntary plea, because as the court said in Manigan, when a court affirmatively misadvises, it's not just a failure to advise, it's an affirmative misadvisement. And when that happens, the waiver of your appellate rights is not knowing and voluntary. And so under
The
Fitzgerald.
waiver of the appellate rights,
Correct.
there wasn't any waiver of appellate rights.
Well, whatever.
There wasn't any waiver. There was a no agreement.
Sure,
There
whatever.
was a no plea agreement.
Whatever.
So what happens when you have a straight-up plea? You plead guilty. I'm guilty, Your Honor. There's a
Yes.
factual basis for it. I know what the penalty is.
Correct, Your Honor, but.
And I understand what's going to happen.
Correct, but Your Honor, every plea must be knowing and voluntary. There is no exception for unconditional pleas to the knowing and voluntary rule. Right? That's, the validity of a plea is required in every case. So if the plea was not knowing and voluntary, the court must vacate the plea and remand so Mr. Thompson can decide anew whether to plead guilty or go to trial. That is the position I'm taking at this point. As I can tell, the court is not interested in reaching the
Was he
Fourth
told
Amendment
by
issue.
his own lawyer that he could appeal?
I don't know the answer. I know in the letter that was filed before the change of plea, the attorney said they had discussed his appellate rights with him. So we acknowledge that, but that was also true in Manigan. In Manigan, the defendant had a conversation with his lawyer about his plea agreement and said he understood it. And nevertheless, this court said, because the district court affirmatively misadvised Mr. Manigan about those rights, the plea was not a knowing and voluntary plea.
But this case is distinguishable once again because there's a plea agreement, and I think in Manigan, I think Judge King wrote that. But the issue there is that the government did not object to the incorrect advisement by the district court. And so I think in that opinion, they said is acquiesced because the government didn't. And then that's why in Manigan, the court said you could go back and change it because there was no objection by the government.
Right, and so that distinction is relevant to whether or not Mr. Thompson can appeal the Fourth Amendment issue, but it's not relevant to whether the plea was knowing and voluntary. Every plea, whether conditional or unconditional, must be a knowing, voluntary, and intelligent plea. There's no exception to the validity requirement for unconditional pleas.
Now, what's our standard of review for this sort of area you got?
The question of whether a defendant waived or gave up, whatever word the court wants to use, abandoned his right to raise issues is de novo, so.
Well, we got a case, Martinez, you familiar with that one?
I don't think so, Your Honor.
2002. If the district court erred in the Rule 11 colloquy, but the defendant did not seek in that court to withdraw his guilty plea on the basis of Rule 11 errors, the Court of Appeals reviews for plain error.
So that's not what this court did in Fitzgerald or Bundy. The court said the plea is invalid, therefore we have to decide what the proper remedy is.
When was Fitzgerald?
Fitzgerald was 2016, I believe.
Well, this would be before that.
Okay, I don't know, Your Honor, except that in that case and Bundy, which were both published decisions, the court, did not, there was no motion to withdraw the plea. In those cases, the court nevertheless said, once we determine there was an invalid plea, we have to determine what the remedy is, and if there was no valid plea entered at all, we must vacate the judgment and remand to the district court. So we asked the court to
But
do
in this
the same.
case, we found it important that nobody tried to correct the judge.
Yes, Your Honor, so I can't speak to, why Fitzgerald or Bundy did not address those cases. But those cases both said when someone, raises an issue that he thinks he's
So
preserved.
he wants to, your request here is for him to withdraw, to have the conviction vacated, not to give him a right of appeal.
Correct,
You're not interested in an appeal right on the suppression.
well, I was 20 minutes ago, but I can tell at this point that the court is not going there. So at this point, yes,
Well, let me ask you
remedy-
this just on that point. If your guilty plea is vacated, it has to go back for another guilty plea, right?
Correct.
And during that guilty plea, would you then reserve the right to
I don't know.
challenge the suppression?
That would depend on the course of negotiations with the government. We have not gotten that far yet, so I don't know.
We'll go back for the trial if you want to do a trial.
And I think there's every
We have to
reason that.
start all over.
Yes, I think there's every reason Mr. Thompson would want a trial, because again, he pled guilty the first time and got zero benefit for it, because he did not get acceptance of responsibility at sentencing. So he has zero incentive to just plead again. He would like a trial at this point, or to at least be able to negotiate perhaps a slightly better deal with the government. So there's absolutely a meaningful remedy to Mr. Thompson if the court vacates the guilty plea here, which is again what the court said it must do in Fitzgerald and Bundy when there's no valid plea. And there was no valid plea here because the district court affirmatively misadvised Mr. Thompson about his rights. If I could, I'd like to very quickly discuss the Rogers-Singletary issue, and in particular the question of Mr. Thompson's duty to report. First of all, I think Sisson and the cases that apply it, Williams and Reyes, say that if two conditions are different on their face, and the government argues that they're actually the same, then as long as the defendant contests the government's explanation, this court will find Rogers and Singletary error, which is what happened here. The government says these conditions, which are facially dissimilar, are actually the same. We contest that. Under Sisson and Reyes, that's enough to resolve the issue. But even if the court doesn't believe that's enough, we maintain the court should reverse because our interpretation of these two conditions is the better one. So the government tries to show that the district to which someone is released and the district where they're authorized to reside are the same by looking at a 1995 Memorandum of Understanding between the BOP and probation and an AO internal document. At most, even if you read those documents for all they're worth, the most they show is that in BOP's mind and probation's mind, those two districts are the same. But that is not how this court interprets supervised release conditions. We don't ask, what does probation think the term means? What does the BOP think the term means? The court doesn't even ask, what does the district court think it means? The question is, excuse me, what would a reasonable person speaking normal, ordinary, everyday English understand the conditions to mean? And I think to me, it's obvious that when a condition says the district to which you are released, it means the district that you are in when you step out of prison. So in this case, that would be presumably New York, where Mr. Thompson is now, and that is not the same as the district where he would be authorized to reside when he goes on supervision. So even just looking to the plain, ordinary language of those conditions, they're not the same, because a reasonable person does not read a 1995 Memorandum of Understanding.
Do I understand these two conditions are both in writing and both in the standard conditions adopted?
Yeah, well, one is sort of in the introduction to the
Right.
List of conditions, and then one is under the standard.
Yeah, but they're
conditions.
both in writing and they're both in the conditions adopted.
Yes, Your Honor.
And there's standing conditions in the district.
So, no, only one of them is in the list of standard conditions that.
I mean, the language you're talking about is that taken from the standard conditions?
Well, one of the two in the judgment is, I forget which one, but one of them is from the District of Maryland's standard conditions, but the other is not. The other doesn't appear anywhere in the standard conditions. So
Which is which?
What appears in the standard conditions?
the standard conditions, I believe, which were the ones incorporated at sentencing, talks about the district in which you're authorized to reside. And then the judgment does have that, but it also adds the district to which you are released. It says both, which is the same error that was in,
How does it connect the two? Or?
no, they're just in separate paragraphs.
I know, but you said, all right.
Yeah, it's not a disjunctive or anything, they're just two separate, unrelated parts of the judgment, this is the same error that was in Sisson, Williams, and Reyes. And in Williams and Reyes, the court did reverse, and in fact, in Williams, the government cited the exact same sources that the government cites here to argue that those two conditions are different.
All right. Why don't we hear from the government?
Thank you, Your Honor.
Good morning, Judge Niemeyer. May it please the court. David Bornstein on behalf of the United States. This is an easy case, or at least it should be. Mr. Thompson raises two
Well, it
claims.
should be, but it's gotten a little bit involved, so you might as well drop the easy part and let us get to it.
Let me begin with Mr. Thompson's Fourth Amendment claim of error and why it has been waived. Now, the defendant has conceded throughout these proceedings that he pleaded guilty unconditionally. He realizes that. He concedes it on pages 2.
Well, he wants the plea set aside.
Yeah, that's my
He-
question.
I thought he gave up on the suppression.
So,
It's not a conditional plea.
yes. And so he can only get the plea set aside if he did not knowingly plead guilty unconditionally.
Yeah, but what did the judge told him that he had a right of appeal?
The judge told him that he did not, so let me get to that, Your Honor. Let me explain why it is that Mr.
But
Thompson.
that doesn't mean what it says. He said, the judge told him he had a right of appeal.
The judge
But
told
you
him.
can get anything you want. But the judge told him he didn't have a right of appeal, and he says he misadvised. Well, that doesn't get him a suppression
No, Your Honor.
appeal.
Let us jump to what the judge said. That is page 403 of the joint appendix. And before I tell you what the judge said, I just want to put it briefly into context. What the judge was doing was complying with Criminal Rule 11B1N. Now, under that part of the criminal rule, the judge is supposed to, and let me quote it to you, apprise the defendant of, and I quote, the terms of any plea agreement provision waiving the right to appeal.
But he didn't have a plea agreement.
He did not, and that's what the judge told him. The judge said, now, I do want you to know that you're pleading guilty without an agreement with the government, so you are not giving up any rights of appeal. And that is true in the sense that normally when a person pleads guilty unconditionally, it renders irrelevant, as your honors know, any pre-plea constitutional error, any non-jurisdictional error.
Well, now, let's just, I understand all that.
Yes.
That's easy to say, but the question is what he was told and what he is entitled to rely on.
Yes.
Court says, now I want you to know that because if you are pleading guilty without an agreement with the government, you are not giving up any rights to appeal. In other words, at the sentencing, you will be able to appeal any sentence that is imposed or any other underlying ruling that the judge made in the case,
Yes.
because you are not giving up your right of appeal.
Yes.
Now, the judge did make a ruling in the case on the suppression.
Yes.
The question is he entitled to rely on that in pleading guilty?
Well, I think the question, so the first question is, what exactly did the judge tell him? And,
Judge, you
Just
might
read
have
it out.
read that to you.
and so if you look at
And
those.
that's wrong.
Well, no, it is not, Your Honor. So first of all, it is correct he didn't have a plea agreement with the government. It is correct that he did not have an appellate waiver. And the judge then tells him, at sentencing, you're able to appeal any sentence that's imposed or any other underlying ruling that the judge made in the case because you're not
But he
giving up your
doesn't leave
appellate
it to
rights.
sentence. It says that the judge made in the case
Yes, Your Honor.
because you are not giving up your right of appeal.
And my
And
friend.
that's because there was no plea agreement. So the court
Yes.
concluded, because there's not a plea agreement, you can appeal anything.
And I think my friend on page 6 of his reply calls that a legally incoherent statement. The government does agree that it requires construction, but we think the best construction of the statement was the judge was simply telling Mr. Thompson that because he did not enter any appeal waiver, he could still bring a sentencing claim on appeal, which is always true once a
Well,
person
now the court
pleads
says
guilty.
again at 408, now as I understand, I mentioned, because there is no plea in this particular case, the plea agreement in this particular case, whatever sentence is imposed does not restrict your right to appeal that sentence if you believe that there's a basis for doing so.
Absolutely. Of
Yeah.
course he can appeal the sentence. And I want to point out, look at my friend's opening brief. The defendant never says at any point in that opening brief that he believes that he thereby retained the right to appeal the suppression order.
Well, it
That
said
to me
any ruling in this case.
said any ruling, but again, I
Well,
believe that the best,
suppression ruling was a ruling
but the best
in
construction.
this case.
Yes, Your Honor, but I think the best construction of that is when the court says you're allowed to appeal the sentence or any underlying ruling, it is any underlying ruling applicable to the sentence, like a guidelines calculation. And I want to point out, look at my friend's opening brief. He never says that Mr.
Well, I think
Thompson.
that's probably what the court intended to say.
And that's
you're
what-
saying, because it's,
Yes.
you can appeal the sentencing, but there's a little bit of a slip in there.
And I don't think the slip led to any misunderstanding on Mr. Thompson's part. Page 28 of my friend's opening brief is the only sentence I could find where he tries to say what Thompson understood from it. And this is what my friend has, page 28. On these facts, where the district court advised Thompson that, quote, he's entitled to appeal his sentence, Thompson can hardly be said to have knowingly waived his right of appeal, close quote. That is the only sentence my friend has in his brief about what Thompson understood, and we agree. He was told he's entitled to appeal his sentence, and that is what Judge Grimm told him. There is no basis here to believe that the defendant thought he had reserved the right to appeal the suppression ruling.
So you're saying he had a right of appeal?
Yes, so when a person...
How do you get a right of appeal if he pleads unconditionally?
As you know, Judge King, even when a defendant pleads guilty unconditionally, a straight-up plea, he can still bring a sentencing claim on appeal, he can challenge his sentence, and also under the Blackledge Mena Doctrine, he can still, this is Class Against the United States, the Supreme Court decision from 2018, he can still bring any jurisdictional pre-plea claim. For example, anything that says that the government cannot hail him into court, like a double jeopardy claim, like a facial challenge to the a facial constitutional challenge to the statute of conviction. Those are claims that he can still raise on appeal despite an unconditional plea. So what Judge Grimm told the defendant was correct. He didn't have a plea agreement.
Can
He
you
wasn't
appeal them
waiving those
without
rights.
preserving them?
Sorry, Your Honor?
Can you appeal those claims without preserving them with the court and make motions to that effect?
Yes, that is Class Against the United States again, Your Honor. The 2018 decision that Justice Breyer wrote for the Supreme Court explaining that despite entering an unconditional plea, in that case, the defendant could bring a Second Amendment challenge to his statute of conviction. And the idea was that that was a jurisdictional
So
claim.
your position here is he's here properly, he can appeal.
Well, no, he cannot appeal the suppression claim because the suppression claim, Your Honor, is a non-jurisdictional pre-plea defect. That is this court's decision in Lozada. But I really want to hone in on why the defendant's guilty plea here was knowing and why he cannot, for the first time at oral argument, claim that it was unknowing and thus he should get his plea back. I want to make that clear. Look at his opening brief. On pages 2, 24, and 29, he repeatedly concedes that he knows he entered an unconditional guilty plea. Again, on page 3 of his reply brief, he concedes that he knows he did not enter a conditional plea. And then look at what happened below. Before pleading guilty, the defendant wrote a letter to the district court stating that he knew that by pleading guilty, he was, quote, giving up the right to appeal any pretrial decisions about evidence. That's Joint Appendix page 383. And in fact, look at my friend's reply brief, page 7. He says that the defendant thereby acknowledged that he was, quote, knowingly giving up his right to appeal suppression.
Can we hold it against him, what his lawyer said in the brief?
Yes,
In this
absolutely, Your
context?
Honor. I think given the fact that throughout the record and in the briefing, the defendant repeatedly says he knew that he was giving up the right to appeal the suppression ruling, that he cannot even get himself in the opening brief or at any place that I can find to say that the defendant actually thought he had reserved the right to appeal suppression. If you look through it, he'll cite case law, but the one time where he says this is what Thompson thought, it's on page 28, and it simply says he was informed of the fact that he could appeal his sentence. And I think that is the correct understanding of what Judge Grimm said on page 403 of the Joint Appendix. Judge
Well, I
Grimm,
suppose you get some confirmation of that at 408.
yes, absolutely, Your
When
Honor.
he repeated it correctly, as opposed to 403, where he slipped in that word "in this case." I suppose he meant the sentencing in this case, but that's probably what he intended, but it is a little awkward.
Well, again, Your Honor, we do not believe that that one awkward moment can overcome the defendant's clear acknowledgments in the letter before the court at Joint Appendix 383. I would also point out that on Joint Appendix page 402, the court spent pages telling the defendant of the rights he was giving up by pleading guilty. You can start on page 395 and then jump to page 401, and the court tells the defendant, if you had proceeded to trial, you would preserve the right to appeal any pretrial decision that you thought was erroneous, but by pleading guilty, you are waiving that right. Do you understand that? That's pages 395 to 401. And on page 402, the defendant says, yes, he understands.
Why is this, he brings up Fitzgerald, how is this different than Fitzgerald?
It is not. What my friend is trying to do here is create another avenue beyond the conditional plea context for defendant to raise suppression claims after pleading guilty. And Fitzgerald completely forecloses that argument. In Fitzgerald, the district court actually told the defendant, I believe the exact words is that you have certainly retained the ability to appeal the suppression ruling. And this court said, despite the court saying that he certainly retained that ability, if there is no conditional plea, there is no ability to appeal that. So my friend was trying to say, well, despite doing an unconditional plea, my client should still be able to raise a suppression claim. That is wrong and foreclosed by Fitzgerald. Now at oral argument, he's saying for the first time, well, despite having always said that my client knew it was an unconditional plea, despite all of his representations to the court that he realized that he was giving up his ability to appeal the suppression ruling, now that he sees that his claim of error is not going to pan out, he wants to claim that his guilty plea was invalid. It is too late to do so. He cannot do that at oral argument. In his reply brief, to be fair, on page 3 of his reply brief, he says, well, you can construe some of my arguments in my opening brief as claiming that I did not knowingly enter an unconditional plea. But look at the arguments he cites. Each and every one of them says that he did not knowingly enter an appellate waiver. And the government agrees. He had no appellate waiver here because he had no plea agreement with the government. He did not waive his rights to bring a sentencing appeal. He did not waive his rights to bring any sort of challenge under the Blackledge Mena Doctrine, those facial constitutional challenges, those double jeopardy challenges. What he did do by pleading guilty, this is the Supreme Court's decision in Class against the United States, is he rendered irrelevant and thus prevented himself from appealing any pre-plea constitutional error that did not fundamentally go to the jurisdiction of the court.
How do we handle the judgment?
I'd like to now turn,
the
yes.
two languages, the residence and district of release. What would she do? Should we do there?
So, as this court set forth in Mathis, and actually just last week in a new decision called Turner, if you'd like me to follow 28G, I will, a Rogers error is only error if there is a material discrepancy between the two descriptions of the supervised release terms.
Both of these are in the written judgment, right?
Yes, they are, Your Honor.
Okay, so, and they're both written there, and
Yes.
they seem to be in tension with each other, right?
Only on their face. Only on their face. They're about as much intention as saying, meet me in Richmond, meet me in Virginia's capital. Those are two different descriptions of the same place.
Well, if he were released now, he would have to report in New York, right?
No, Your Honor. My friend completely ignores release planning. So what the government has done is we've produced documents from the Bureau of Prisons and also the Probation Department and also the Administrative Office of the U.S. Courts, showing that the district to which a defendant is released is also the district to which he is authorized to reside in. And if you'll just give me 1 second, Your Honor, I'm going to pull up these documents.
You mean the release is a physical document that he gets? When he's released, does he get a physical document that says you're released in this state, but report to the state of your residence?
What we're saying, Your Honor, is the BOP does not simply let an inmate out the front doors of the prison and saying you now have 72 hours to get to wherever you need to go. That's not what happens. The BOP actually transports the defendant to the district in which he is going to be supervised, to which he's authorized to reside. That is the district he is released in, and that is made clear through the documents that the government has put forward, which this court can take notice of.
So you're saying that under BOP regulations, the language that says the district in which he's released doesn't refer to where he walks out of the gate, but where he's transported after his incarceration is finished.
Exactly. It is that he's not released out of the gate. The BOP, so for example, the BOP generally, in most cases, before a defendant is released, they allow him to complete his or her sentence on home supervision, or the person is allowed to enter a residential reentry center. Both of those places are going to be in the district in which he is authorized to reside. Now,
Which is that? Is that Maryland in this case?
in this case, I'm not sure that the defendant actually has a release plan yet. What will happen is the defendant is currently serving a 30-year sentence. Once he starts to near the end of that term, he will file a release plan where he sets forth where he would like to reside. BOP and probation then work together on how do they get him there. Ideally, he will be allowed to spend the last 6 months of his sentence, again, in either home confinement or at a residential reentry center, or if there's no suitable place to put him, these are the documents we put for the BOP memorandum. He can be placed in a local or state jail so that he will be released from there. The point is, Your
So you're
Honor.
saying release is a term of art, not where he walks out the gate, but where he is released by the Bureau of Prisons, which is the place of his authorized residence.
And I'm actually saying, Your Honor, he doesn't, when he will walk out the gate, it will be from a facility in the District of Supervision. So the defendant right now is in New York. I think, I'll put it this way, Your Honor. I think it is telling that my friend, despite there are now years of litigation as to whether the district of release and the district of authorized residence are the same, despite the government, in case after case, putting forward evidence that they are actually the same. Indeed, my friend stood up here and said, if you look at the BOP and probation documents, they show that they are the same in the mind of the BOP. And in probation, well, that's meaningful, because BOP is the government agency releasing the defendant. And if the BOP is releasing the defendant into his district of supervision, into the district where he's authorized to reside, they are one and the same. My friend simply responds saying, well, you know, it's almost like a movie. Imagine the prison gates open, the defendant walks out, and he's told, okay, you're being released from New York State, you live in Alaska.
There's usually a big array of press there taking pictures and stuff.
Yeah, right? It's fictional.
But so your position is that he will not be released in New York. He would maybe transported from New York to
Yes.
where he resides.
He would be brought to a detention center in Maryland, or he'd be put into home confinement in Maryland, or he'd be put into a residential reentry center in Maryland. The government has come forward with documents showing that. I just want to quickly quote from the BOP, the Memorandum of Understanding between the BOP and the Probation Department. We cite it.
Have you
in
made
our
any
brief.
effort to conform the judgments to what you're going to tell us?
What do you mean, Your Honor?
Well, they're saying that what happened at the hearing is inconsistent with what's in the written judgment.
So,
And that's what they call the Rogers error.
yes.
Okay, and you're trying to explain there's no Rogers error because of what the BOP writes down.
And not only that.
The judgment is what needs to say what the judge said, or the judge needs to say what the judgment says.
And I'd like to point out, Your Honor, look at Joint Appendix page 510. Both of these descriptions of the condition exist on the same template that the District of Maryland uses in every sentence. In every sentence, it describes the condition twice, but they mean the same thing. Within 72 hours of your
If I
release.
understand you, the word release is where the BOP releases him,
Yes, Your Honor.
not where he last served in jail.
Exactly.
And the place he's released is always the place he's authorized to live.
Yes, Your Honor. And we have come forward with documents showing that, the POP and probation joint memorandum, the Administrative Office of the U.S. Court's own overview of these guidelines. I'd simply point out, if I may quickly, pointing at the BOP memorandum, it says, under District of Supervision, offenders should be released to locations where they have the greatest likelihood of a successful community adjustment, thereby showing that the BOP.
That all sounds great, but what we're concerned with is what the judgment says as opposed to what the judge said. And somebody has a responsibility to get the order right.
Sure, and let me clarify.
Yeah, and you're one of the lawyers in the case.
Yep, and let me clarify. So the two descriptions are the same, Judge King. The two descriptions, because the district of your release is also the district in which you're authorized to reside.
Why can't they say it in the same terms? They don't have, you don't have to come to Richmond to try to explain it to 3 other judges.
It would definitely simplify things, Your
Well, it
Honor.
would.
But when it comes to a Rogers error, this court is clear that only a material discrepancy matters, and I believe the onus is on the defendant as the one seeking relief to show there's a material discrepancy. This court should reject the argument of the defendant. He says under this court's unpublished decision in Reyes, he simply has to object to the government's reading despite all the evidence we bring forward. He just has to say, I contest it, and that is a Rogers error. If that is true, and given the fact that the District of Maryland, every single judgment has these two descriptions of the same condition in it, I would argue that the fact that they are both together shows that they're one and the same. It's also not far-fetched, Your Honor. The Fifth Circuit, in a series of decisions, I'll quickly cite them to you, Your Honor. U.S. against Hamdouni, 2021, Westlaw 557-9267, U.S. versus Williams, 2022, Westlaw 636-681.
Which circuit, you talking about, Fifth or First?
The Fifth Circuit. The Fifth Circuit has...
But they do it differently than we do.
No, they go to see whether or not these two descriptions are different. And the Fifth Circuit has determined, based upon the evidence that the government has put forward, same exact evidence the government has brought forward here, that the two descriptions refer to the same district, because the district to which you're released is the district in which you're authorized to reside. And I find it deeply telling that my friend doesn't bring forward anything to support his reading except this sort of fanciful notion that the BOP simply
No, I'm
opens
asking
up the
you
prison
why
gates.
why the court and the lawyers can't get the two things consistent with one another.
And my answer
You're
to
saying
you-
they have consistent meanings,
Yeah.
but Judge King has pointed out they have different words.
Yes,
It'd
they-
be better
they-
to have consistent words.
Yeah, they do, they have consistent meetings, they are different words. It definitely would
And
simplify things.
Maybe the U.S. Attorney needs to talk to the chief judge or the probation officer or somebody. And
Yes.
It's a matter of drafting the order, I guess,
I-
or the standard conditions, or whatever you want to call them.
I think that
Of the one you're dealing with, but it ought not to be too difficult.
there would be no question, Your Honor, that there is no Rogers error here if the district court simply eliminated the description of the
Don't blame it on
condition.
the district court. I'm not going to let you blame it on the district court. I think I'm going to blame it on everybody involved. I mean, particularly the lawyers. I think the responsibility are on the prosecutor and the defendant, lawyers.
Your Honor, if I just may say.
And the same thing with this other issue on the plea agreement.
Well-
No plea agreement.
You just send a letter to the district court chief judge.
Of course.
And tell him to make the language consistent, and it'll save appeals.
And when it's wrong, you can make a motion to amend it. Or fix it, or
And
do
Judge
something
King,
else.
I'll point on Judge Niemeyer. I was
Wait
at.
and come to Richmond and argue about it.
I was at a resentencing last week where I pointed out to the district court that there were these two descriptions of the same condition and that there had been a lot of litigation about them being inconsistent. Judge Bradar in the District of Maryland said, well, they describe the same district. They're one and the same. And
But that's in the context of a case. You need to write a letter
I understand, Your
independent from
Honor.
the case to be neutral.
But the most important thing here is it is not enough for my friend to come up here and say, producing no evidence, producing nothing that shows that these two are different, the mere fact that he contests it is enough. The onus is on him to show why the government's reading is wrong,
All
and
right,
he
let's
has
hear
not
from
done
him,
so.
okay?
All right, thank you, Your Honor. We
Yeah.
ask you to affirm.
All right, thank you, Your Honor. A couple points. First, on the guilty plea, the government says that in our brief, we said that Mr. Thompson knew that he was not preserving his suppression rights. That is absolutely not true.
Well, just let me take you to something that I didn't bring up a little earlier, but it's part of the calculus. On page 399, the district court told the defendant this: in addition, during or before the trial, your lawyers could have filed a motion to try to limit the evidence the government would produce, and the judge would have to rule on whether that could be heard when the government finishes its case and say, we don't have any more evidence to offer. We're done. Then, with the assistance of your lawyers, you would be required to make a decision, and you basically would have two routes to go from that point. That motion to limit the evidence, the court then says, a couple of pages later, you're giving that up. Do you understand? And he says, yes. And then you go back to 408, and the court explains the right to appeal is related to the sentence. The place you rely on is 403, where it has the one phrase in this case. But I'm wondering whether when the fella is told that all your motions to limit the evidence, you're giving that right up.
So
And he says, yes, I know.
So I don't think that's actually what happens, Your Honor. So Judge Grimm reads through all these things that the client could do if he goes to trial. And he says, do you understand what it means to have those rights? Meaning, do you understand that if you go to trial, you can do those things? And he
Well, it
says, yes.
says also the motions made, file motions to say to limit the evidence.
Right. In other
Before,
words,
say, during or before trial. The court says that.
correct. So
And you filed a motion to suppress, which is a motion to limit evidence.
yes. The district court, though, what the district court told Mr. Thompson was, if you go to trial, you will have that right.
It didn't say that. It says if you don't plead, when you plead guilty, the court said you're giving up that right. He didn't say you don't have that right. It said, in addition, and then it said, all right, and he goes through this whole thing and says, you're giving up all those rights, you understand? And he said, yes.
So if you're referring to the bottom of page 402, which I think you are, Your Honor. but the
Now, I was
court-
on 399.
Okay. Well, on 402, which is the one that immediately precedes page 403, the court says, when you plead guilty, you give up these important constitutional rights. And immediately before that, the court is talking about 3 specific constitutional rights: the right not to incriminate yourself, the right to confront witnesses, and the right to have a jury trial. And he says, do you understand that you give up these constitutional rights when you plead guilty? But the appealing is not a constitutional right. There is no constitutional right to an appeal. So, but anyway, even if the court thinks that statement at the bottom of 402.
Well, you missed the top of the page. It says, this is after he explains the motions. The court says, do you understand what it means to have these rights that I've just explained to you, sir? Defendant, yes, sir. All right, now, why I'm going through all of that with you? Well, it's because when you plead guilty, you give up these rights.
Sure.
That's not down there where, he's talking about a different thing.
Yes.
It's just as clear as a bell in my judgment that the motions to limit evidence was explicitly told to him that he would be giving it up.
Well, so 2 things. One, I think the court, after that part you just quoted, transitions to a separate set of rights that he's talking about. But even if you disagree on that, Your Honor, when we get to page 403, the language is, in my mind, extremely clear. It says, if you are not giving up any rights of appeal. If the government tries to say that that's ambiguous, I don't see how that can be ambiguous. If the court says you're not giving up any rights of appeal, and you will be able to appeal any sentence that's imposed or any other underlying ruling. In other words, not just sentencing rulings, any
The
other
court
underlying
said,
ruling.
in other words, when you took that language, it said, not giving up any rights of appeal. In other words, at the sentencing, you'll be able to appeal any sentence that was imposed or any other underlying ruling, and that underlying ruling should be construed to be the sentencing that the judge made in the case because you're not giving up your rights of an appeal.
Well, Your Honor, then there'd be no reason to use the word other.
And then
Maybe
look
then,
at 408, the court says, as I mentioned on 408,
well, the court did also mention the right to give up appeal of sentencing. So he's talking about
and
both.
then the court said it again at the end of the sentencing.
Well, what the court said at the end of the sentencing is you have an unlimited right to appeal.
Yeah.
And then at sentencing, the court again said you have the right to raise any appeal you want. So at most, I think the transcript is ambiguous. And when that's the case, the cases we cite in our reply brief from the D.C. Circuit and the 10th Circuit say if it's ambiguous, you construe the waiver narrowly. And so that means the plea is not knowing involuntary.
Okay, I'd say our
What
time is.
waiver?
I'm sorry?
What waiver is
Now-
being construed narrowly? There were no waivers.
Sorry, let's put aside the word waiver.
I think you better get that done.
Ability to enter the plea knowing that you won't be able to appeal, that is not a knowing decision.
Maybe we review for plain error.
Well, the government hasn't even suggested that you review for plain error. And again, Fitzgerald and Bundy are very clear that it's a de novo review. The court just decides what the remedy is and does it without, dwelling on the fact that the defendant didn't file a motion
Well,
to.
if it's going to be de novo, the council would have to frame it in the proper manner of the issue. And the way you framed it, it all had to do with the appeal of the suppression.
But the reason that I was arguing the court could
And
get
you'd say
to.
today that doesn't have anything to do with it anymore.
Well, I'm saying I realize the court is not going to go in that direction, and so, but the reason that I thought the court, and still think the court can get there, is that the plea was not knowing and voluntary. And the government stood up a second ago and said that we never said in our brief.
I think we understand.
Okay.
We're past the red light. We've given a little more time on this case than we
Thank you, Your Honor.
had assigned. We'll adjourn court for the day and then come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.